Well, good morning, everyone. I see it's 8:45 and want to be sure we start on time so we get through this wonderful program today. I'm Michelle O'Neill, your current WHCRMS president, and wanted to just welcome you and thank you for joining the 37th annual conference, Resilience in Unprecedented Times. It's hard to believe that now, 1 year later, we are still in a virtual environment and not face-to-face at the WAC. I know we all love going there and seeing each other and having the opportunity to network. And we are hoping that in the very near future that we will be able to at least have some social event where we can all be together face to face and see each other again. Our lives will probably be changed forever because of this pandemic. And I just want to thank all of you for your continued support of WHCRMS, your attendance at our educational offerings, and the work you do every day is so important. And I know it's been extremely challenging and stressful for many of us over the many, many months that we've been going through this. Again, it's so important that we can be here to support you in what you do. And your participation has just kind of reinforced that our chapter has been able to continue to thrive and to offer educational opportunities and support to you in your careers and your jobs. So first, I'd like to take the opportunity to introduce our current board and just let you know how much I have appreciated them this last year. They have been remarkable, to say the least. Made my position as the president very, very easy. Never said no, always willing to step up, went the extra mile, and it's just been a pleasure to be with them this last year. So our current board, our president-elect is Michael McDermott, Treasurers Ann Clark, Secretary Sarah Silverman, Past President Noah Wick, Western Washington Trustee Roxana Jessen, Western Washington Trustee Shelley Nick, Western Washington Trustee Tim Hall, Eastern Washington Trustee Erica Roberts, and Eastern Washington Trustee Leslie Robinson. Again, I can't thank you enough for all that you've done, and it's just been a pleasure. I'd also like to take the opportunity to introduce our outstanding conference committee. They've had double work this year. We did a virtual conference in the fall. We had to pivot really fast last year to try to figure out how to continue to have our conference in a virtual world. We actually planned for both, and that is just an unbelievable amount of work and commitment by the committee. And they continue to work this year to come together and put together this wonderful conference for all of you. So the conference committee, again, I have Ann Clark, I have Roxana Jessen, Erica Roberts, and I know that Sarah Silverman also was very active on that committee. So again, I want to thank you again for putting together a wonderful program and for all of your hard work and commitment this past year. It's been exceptional. So with that, I'd like to take the opportunity to let you know a little bit about our program this year. It's really about resilience, and I think the theme and the topic really fits what we've been going through this many, many months. So I have the honor and the opportunity to introduce our first speaker, the Honorable Helen G. Whitener, Justice, Washington State Supreme Court. She's got quite the impressive resume, as you can imagine, and so I'm going to highlight just a few of those things on her bio. Justice G. Helen Whitener was appointed to the Washington State Supreme Court in April 2020, and she was elected by the voters to retain her position on the state Supreme Court in November 2020. Prior to her appointment to Washington State's highest court, Justice Whitener served as a Pierce County Superior Court judge. Justice Whitener also served as a judge on the Washington State Board of Industrial Insurance Appeals and as a pro tem judge in Pierce County District Court and City of Tacoma Municipal Court. Before becoming a judge, Justice Whitener litigated both civil and criminal cases for 14 years, first as a prosecutor and defense attorney, and later as a managing partner of the law firm of Whitener, Rainey, Ritt, P.S. Justice Whitener is the first Black woman to serve on the Washington Supreme Court, the fourth immigrant-born justice, and the first Black LGBT judge in the state of Washington. Justice Whitener is often invited to speak to organizations locally, nationally, and internationally on human rights, access to justice, and the responsibility of the judiciary to ensure the right of all who appear before the court to basic dignity and respect in judicial proceedings. Justice Whitener was born and raised in the Caribbean island nation of Trinidad and Tobago. In 2015, at the request of the United States Embassy, Judge Whitener visited her home country to speak on human rights. Justice Whitener earned her BA degree in Business Administration and International Marketing from Baruch College, New York, and received her JD degree from Seattle University School of Law. Justice Whitener lives in Pierce County with her wife, attorney Lynn Rainey. And with that, I'd like to turn it over to the Honorable Helen G. Whitener. Thank you.
Thank you, and good morning to all of you. And I'll first start by pronouncing my last name. It's Whitener with an E and not Whitner without the E. But having said that, you're not the first one to do that. So good morning, and thank you for all allowing me the opportunity to start your day, sharing my perspective on the important theme of your conference this year, resilience in unprecedented times. Psychologists define resilience as the process of adapting well in the face of adversity, trauma, tragedy, threats, or stress. But rather, I see it as not having the adversity, the trauma, tragedy, threats, or significant sources of the stress take control and affect your perspective of who you are. I was told I can talk about what it means to me, so I'm about to share, and I tend to share from my truth. So as you heard, I was born and raised on a small multicultural island, and my identity as a Black female was strengthened by strong female family members. It really takes a village. I was active in sports and acquired awards in track and field for my physical agility. I had completed the equivalent of an American high school diploma and was doing my advanced studies in preparation of attending university in England. Then at the end of class one day, I was unable to move. It was as if everything had just shut down. I was paralyzed on my right side. The word disability was not something I had any knowledge about, and I had never given it any thought. I was 16 years old. All of a sudden, I needed assistance from others to take care of my basic needs. My paralysis introduced me to ableism, the feelings of not being included. Assumptions were made about my ability to participate, but no thought as to how I may be able to participate. After all, my mind worked just fine. People would speak at me or over me, but not to me. It was as if they did not want to see me. I continuously saw disappointment in people's faces and was continuously reminded that they saw my disability as my lost opportunity to become accomplished, independent, educated, or worthy. Medical care on the island in those days was not as advanced as it is today, and the doctors, unable to figure out what happened to me, sent me to the United States for medical care. I felt like my world was over. My dreams and goals of attending university in England and my future, as I had envisioned it, I thought was never to be. My life, I thought, was over. I became depressed. I gained 50 pounds in a few months, and to be honest, my future was not looking bright. About 6 months into my physical rehabilitation, things began to look up. So I took some advice from one of my cousins, and I applied to attend an American college. It was the school she attended, Baruch College. I was still 16, and I was accepted. Things started to look brighter. But I continuously fought being labeled disabled. I did not want the limitations society placed on me because of that label. I experienced many relapses as I was my own worst enemy. In fact, it took me 6 years to complete the 4-year degree program because I continuously overextended myself. My parents and teachers instilled in me a sense of personal and cultural pride. I grew up surrounded by stories of my ancestral history. My parents and teachers told me that I am a descendant of kings and queens, and I believed them. When you live on an island, vacations are not going to another island, but rather it is traveling off the islands. So most summers, that is what we did, as my mother was a teacher and my father a school principal. It was when we traveled. The summer of 1976 was the first time I visited the United States. We visited my father's brother, who resided at the time in Brooklyn, New York. I remember that I was both intrigued and perturbed by America, and I still am, even to this day. Growing up, I learned about the National Association for the Advancement of Colored People, the NAACP, as a human rights organization. I was intrigued. A powerful group of civic leaders who advocated for equal rights for Black people and people of color. I saw documentaries of sit-ins, news reports about encounters and fights with law enforcement. I saw photos in major magazines of beautiful Black people. And I also saw photos of white police officers using dogs and water hoses, kicking, punching, and hurting men, women, and children, the majority of whom were Black. I saw photos of Black men and women sitting at a restaurant counter, refusing to leave and just asking to be served. I saw photos and read stories of Rosa Parks refusing to give up her seat in the front of the bus, demanding to be afforded the right to sit wherever she pleased on the bus that she paid to ride in. I was intrigued. I saw Black pride with the Black Panther movement and was taught about people like Stokely Carmichael, a Black Panther and civil rights activist who was born in Trinidad, my birth country. I heard chants like, "Say it loud, I'm Black and I'm proud," or "What do you want? Justice. When do you want it? Now." Fast forward 40 years later, I see Black pride in the Black Lives Matter movement, a powerful group of civic-minded leaders who are advocating for fair and just treatment for Black people. I see daily protests, news about shootings with law enforcement. I see photos and articles in local, national, and international newspapers and magazines, Facebook, Instagram, and Twitter, of beautiful Black and brown people, and photos of white police officers using tear gas, kicking, punching, and shooting men, women, and children, the majority of whom are Black. I see videos with stories of Black people, too many to count, refusing to be removed from restaurants, mass transits, hotels, parks, their cars, their apartments, their homes, demanding to know what they did wrong. I hear new chants, like "Say their name," "Hands up, don't shoot," or "I can't breathe," along with the old chants, "What do you want? Justice. When do you want it? Now." Unprecedented means never done or known before. So unfortunately for me, there is nothing unprecedented about these times. Racism and discrimination places a person at risk of questioning their self-worth. As a Black queer immigrant woman with a disability, maneuvering through life in America has required that I be resilient to avoid the risks associated with the continuous psychological distress I encounter daily. I have persevered in the face of these daily adversities that are outside of my control by first acknowledging they exist, that racism is real and it exists, and second, refusing to have that acknowledgement define who I am. In 2015, I wrote the poem "It," I-T, which stands for Identity Transcendence, and it is the poem I read in my TEDx talk, Claiming Your Identity by Understanding Your Self-Worth, and I thought it was worthy of reading again today. It says, "How dark is the color of its skin, as that will define its struggles within. Is it a boy or is it a girl was asked, as if important to assign its life's task. Will it stay or will it go? The answer its parents needs to know. From the day that it was born, its very essence society scorned. At birth, society coded its future to doom. It hacked the code and redirected its future to Zoom. Silent, it could never be, because it, ladies and gentlemen, is me. Racism and discrimination is trauma, and it is the trauma that I refuse to succumb to. The question is, how do you rise when from birth this society keeps telling you that you do not matter? That because of the color of your skin that you are less than, not worthy of, or not equal to others? How do you rise when the very essence of your being is continuously under attack because of who you love? How do you fit in when you know that you were born to stand out? You cannot address a problem until you acknowledge that there is a problem. Racism, sexism, ableism, homophobia, xenophobia is discrimination, and they are the problem. They are all tied to institutional systems with systemic barriers associated with inequality and inequity. Race, gender, sexual orientation, immigration, and disability. Labels that are used in society to preordain lives to servitude, enslavement, oppression, exclusion, and powerlessness. Resilience is the ability to find your voice. I found my voice many years ago when I made the choice to be vocal, visible, and vigilant, to live my life as my authentic self, to demand not only to be heard, but also to be seen and treated as an equal, as a human being, and to be respected while doing so. In fact, my pursuit of becoming a judicial officer was in part because I knew that my race, sex, sexual orientation, disability, or my being an immigrant said nothing about my abilities or potential. And I believed that these qualities would add to the interpretation and application of the law and not detract from it. In the 60s, Dr. Martin Luther King gave his I Have a Dream speech. And 50 years later, I have to say that I really wish we could have met under different circumstances in line with his dream, where we are judged on our character and not on labels that are used to separate us. Labels such as our race, the color of our skin, our gender, who we love, where we are from, what job we have, what title we hold, how much money we make, or how you are excluded for having a disability. Being perceived as a less than based on labels is not only incorrect, but it ignores the very essence and worth of a person. You see, who I am is the color of my skin, is my gender, is where I was born, is who I love, amongst other things, and is, in spite of my appearance, my physical inability to maneuver this world the way I am perceived. I don't have the privilege of being silent on issues that affect me. So even though my perspective may not be privilege-based, it is still worthy of consideration. A few months ago, a white male judge in the audience at a presentation I gave said that he was having a hard time understanding how someone with all of my accomplishments could be seen as marginalized or not privileged. Valid question. My response was simple, as I educated him on what I term the baggage of racism. You see, unlike someone that looked like him, my accomplishments were not because of support received from society, but was actually in spite of the barriers society placed at every step of my journey. I shared that when society sees me, they see a Black woman. And unfortunately, with that comes the baggage of racism. And but for the titles, judge, and now justice, I am not seen. You see, my reality is that the title judge or justice comes with a black robe, and it is the black robe that garners respect. The title garners respect. At the end of my workday, when I disrobe, I maneuver through America in black skin. My reality is being followed when shopping in a store, having my credibility challenged when I use credit cards, being concerned when I see a police car pass or see lights and sirens behind my vehicle when I drive, being concerned not to be in particular neighborhoods at certain hours, being concerned when going home late at night of being stopped because I could not possibly live in a certain neighborhood, or telling a friend that I would not pick up a package she left for me on her front porch due to my concern that someone would call the police on me because she is white and lives in a predominantly white neighborhood. My marginalizing identities overlap and intersect with systems of oppression and discrimination that remind me daily that I'm not privileged. I am standing over here wondering if you can see me. You invite me in, and I'm so excited to join you and to have a seat at the table. I'm just blown away by your generous act. But then when I stand to join you, you seat me, close enough to be seen, but far enough away to not be heard. And when I try to speak, you silence me, making it clear that my voice is not to be heard. I then realize that everything about our interaction says I am to know my place, and the message delivered is I am here for the optics. There are many features that we share, but there are aspects of what makes me, me. So when you look at me, what exactly is it that you see? Because I see you, but do you see me? When I speak, what exactly is it that you hear? Because I hear you, but do you hear me? We are here to work together. So why is it so hard for you to respect me? I really want to speak to you, but will you listen to what I have to say? I cannot just be a face at the table. I cannot just hold a space. I have a voice that strains to be heard as I always speak from my truth. I have so much that I want to share, but with my narrative be understood. My lived experiences involve being on the receiving end of acts meant to instill fear and to silence my voice. But silence would allow others to define and control who I am and how I will be seen. Silence allows others to tell your story without your input. I knew the power of my voice was mine, and my narrative was only mine to share. My resilience comes from understanding that with resilience comes accountability. Accountability to myself and to the others who are unable to speak or are not seen, and in knowing that I'm not special. Resilience requires that we not just be right, but that we do right, as that builds not only our self-worth, but that of others. An understanding of your worth is a never-ending journey that requires that we stop looking for validation from outside ourselves and find it within. My experiences in the last year, with its many physical, mental, and emotional stresses brought on by a worldwide pandemic, was painful and distressing, but it was not unprecedented in the way you may think, as I've discussed. It was another trauma that unfortunately the trauma of racism had prepared me for. I was a 16-year-old paralyzed young girl when the fear of not envisioning a future almost silenced me, almost silenced my voice, almost silenced my input, and almost silenced my options. Last April, almost 40 years to the date that I arrived in the United States, I was appointed to this state's highest court, the Supreme Court. I I became the state's first Black female Supreme Court justice, its fourth immigrant born. I was already the only Black LGBTQI judge in the state, and then I became the first Black LGBTQI Supreme Court justice, not just in our state, but in the nation. Later that year, I prevailed in my election, becoming the first Black elected official to win a statewide campaign in our state. That was 2020. Yes, in some respects, unprecedented things have occurred, but we are not living in unprecedented times. The systemic inequities exist today as they always have. And if we think of these as unprecedented times, we are likely to forget the trials and tribulations of the past that are still present today. But I am resilient, which means I do believe that we have the power to create unprecedented solutions. Unprecedented solutions to address the systemic inequities that have not been successfully addressed in the past. But first, it requires that we acknowledge the history of racism, the history of sexism, the history of ableism, and all of the isms. The history of the phobias, xenophobia, homophobia, and all of the phobias. And in formulating the solutions, we must include the people most affected to participate. I coined a slogan in my TED Talk that I end with most of my talks, end today with it, and it is, we have differences, but we are not truly different. Thank you for giving me a space where my voice can be heard and an opportunity to share with you this morning. Thank you.
Thank you, Justice Whitener, for that powerful message and reminder for all of us. Your story is just shows how much passion you have for what you do and your commitment to where you are and where you've come from. And we thank you very much for that. And I apologize for mispronouncing your name. My sincere apologies. But thank you so much. That was just fabulous. It was wonderful. And what a great way to start our meeting today. And thank you for all you do.
Thank you. And thank you for having me. Have a wonderful day.
Thank you. And with that, I would like to introduce our next session and our speakers. We're a little bit ahead of time, but I think we'll go ahead anyway. The next session is our legislative update with Zosia, Stanley, and Shirley, and I'm going to probably say your name wrong, Prasad, I believe. But let me introduce both right now. Zosia Stanley serves as Associate General Counsel at the Washington State Hospital Association. WSHA represents all the hospitals in Washington State and works to improve the delivery, quality, accessibility, and affordability of healthcare. Zosia is responsible for key legal and policy issues that impact hospitals and healthcare systems, including healthcare affiliations, transparency, charity care, and post-acute patient placement. Prior to working for WSHA, Zosia worked as an attorney in private practice. In that role, she counseled private sector healthcare clients on transactional and litigation matters. Zosia earned both a JD and Master of Health Administration from the University of Washington. Shirley Prasad is a Senior Policy Director at Washington State Hospital Association and responsible for a variety of policy areas at WSHA, including behavioral health, insurance and coverage, and advocacy. Prior to working at WSHA, Shirley was the Director of Public Policy at Community Health Plan of Washington and the Director of Government Relations at the Washington Association for Community Health. Her work in these roles included pursuing state and federal policies to increase healthcare access for low-income Washingtonians and improve health equity. Prior to working in healthcare policy, Shirley worked as an attorney in private practice and consultant at a Big Four accounting firm. Shirley earned a Juris Doctor from the University of San Diego. She also holds a Master's of Laws in Taxation and a Master of Health Administration from the University of Washington. Please welcome our two speakers. Thank you for joining us today.
Thank you.
Yeah, good morning. So we have a PowerPoint slides, and I'm not sure if we want us to show those or if somebody else is going to show those on our behalf. I don't know, Michelle, if you know.
Please go ahead and share.
Okay, that is good to know. All right, let me do that. Please pause with me for a moment while I master this technology. Okay, so I think I'm sharing my screen, but I want to check to see if you all can see my first slide, which should say 2021 legislative session, legislative update, the good, the bad, and the virtual.
Yes, you're good.
Yep.
Zosia.
Great, thanks everybody. So good morning, as mentioned, I'm Zosia Stanley. I'm the Associate General Counsel at the Hospital Association, and I'm very happy to have Shirley Prasad here as well, who's our Senior Director for Policy, or Senior Policy Director. And we are going to talk about the legislative session that just ended, just feels like just a little while ago. It's been about a month. And we are, as I mentioned, the good, the bad, and the virtual. It's our first virtual session we've ever done. Obviously, lots of interesting things happened in COVID, so this is one of them. And let's see, there we go. So today, talk about, as I mentioned, overview of the legislative session, talk about some of the budget and policy results that may impact hospitals and patients and you all, and talk about what might be on the horizon for 2022. It is weird to be thinking about 2022 already, but that is where we are. And Shirley and I will go back and forth. We'll do a deeper dive on some of the issues we hope would be of interest to you all. But we would welcome questions as they occur to you. Happy to have you chat them in. We'll try to answer them as we go along, or we'll see if we have time at the end to answer some. But it's always more fun to answer questions versus you all just listening to a couple talking heads for an hour. So we are happy to entertain questions. And also want to say really thank you for inviting us back to talk to this group. We've talked to you all for a couple years in a row, and hopefully we'll see you all in person someday soon again. So there we are, there's our faces. So first, a little bit about WSHA, in case you are not familiar. The Washington State Hospital Association is a trade organization and advocacy group. We do advocacy and work on behalf of all the hospitals in the state of Washington. We're very honored to have universal membership from all the hospitals. This is our map, which I think is always interesting to see where all of our hospitals are across the state. There are about 112 hospitals in the state. So WSHA's main areas of work are government affairs, which is where Shirley and I mostly work. Quality and safety, we do a lot of work on best practices and harm reduction and improving the overall quality of care in our hospitals, because the mission of the association is to support the mission of our members to provide quality care and access to good quality care across the state. We also do coordinated action on big events. Obviously COVID was our most recent big piece of work. We find there's a lot of power in unity. For instance, during COVID, we were one of the only states that we're aware of that all the hospitals in the state agreed together through the association that no hospital would reach crisis, because all hospitals would work together to transfer patients and support each other. And then we also do a lot of data analytics work. Obviously, healthcare is a data-driven world, and that is part of the service we offer to members, is a lot of the data analytics. So our membership, as I mentioned, 112 hospitals, both for-profit and nonprofit, the military and veterans hospitals, long-term care. Many of the hospitals, as I mentioned, nonprofit, also public hospital districts. So with that as a background, we'll move into the 2021 legislative session, and I'll turn it over to Shirley.
Great. Thank you, Zosia. And good morning, everyone. I'm Shirley Prasad. Yes, Michelle, you pronounced my name correctly. Thank you. And I'm a Senior Policy Director with the Hospital Association, and it's a pleasure speaking with you this morning. So we wanted to really get into our policy issues, but before we do, we thought it was important to do a little bit of context setting. And, for those of you on the call who've heard other WSHA presentations this year, some of this will sound familiar, but, we thought it would be really important to do this context setting, because it'll help explain, some of the budget and policy outcomes we had this year in the 2021 legislative session. So I'll start by just sharing with you in Olympia, we have a solid Democratic majority in the legislature. So Democratic majority in the House and in the Senate. And this is really important to keep in mind because it has an impact on the legislative priorities and themes that we see coming out of Olympia, which would be very different if, thank you. Which would be very different if we had a split legislature or we had Republicans having a majority in the House and in the Senate. And in a moment, I'll talk about some of the themes that we saw in the 2021 session. Next slide. Thank you. So as Zosia mentioned, this was our first ever virtual session. So this is a result of, unfortunately, COVID-19. So what this meant is that when we had committee hearings, this was all done courtesy of Zoom or Teams. Floor action was a little bit of a hybrid. We had some legislators actually show up in person, but others were doing it from the comfort of their home. And so some really interesting consequences of this. So number one, it just takes longer for bills to get through committee, to be debated and voted on the floor. So we had a significantly less volume of bills being introduced and passed this year than we have in other years. And another interesting consequence is around just direct lobbying. I mean, a key piece of lobbying work that happens when you're in Olympia is having those spontaneous conversations. If you're a seasoned lobbyist, sometimes like what stairwell legislators take or where they park, and it makes it a little easier to snag that 5-minute conversation. And you can't really do that in a virtual session. And it's so much easier for a legislator who, if they don't want to talk to you, can ignore your voicemail or your text message. So very different way of doing lobbying this year. Next slide. Thank you. So the legislative themes that we saw. So it's really important to remember that the 2021 legislative session was actually the first session we've had since the beginning of the pandemic. Last year, really kind of the pandemic took off at the end of February, March, and that was around the time that that session ended last year. So there was a lot of pent-up energy and demand for addressing the COVID-19 pandemic. So you can see here the response to the coronavirus was front and center in terms of the bills and the budget issues that we saw this year. There's a lot of energy around doing something around police accountability, and this stems from the tragic murder of George Floyd and the brighter spotlight on social injustice. Also, a lot of attention on racism and inequity, and especially in here are issues around health inequity. So we saw a number of bills trying to address inequitable access to health care. Taxes and spending was another big theme that we saw, especially at, this was true last year too, in terms of, well, what is going to be the economic impact of the pandemic and how does the state budget address that? And then, of course, behavioral health. This has been a continuous theme for legislators over the last few years. So really trying to address the continuum of care when it comes to mental health, substance use disorder. Next slide. So the last slide that I have in this introductory section, we thought we'd share some we think it's fun facts about the session. So the 2021 session was for 105 days. It started in early January and went through the end of April. And it's what we call a long session. And we call it that because one of the key things legislators need to do is pass a budget for the next 2 years, so the next biennial budget. And then you can see here, lawmakers introduced just over 1,000 bills this year. So just to add some context to it, normally in a long session, we see about a little bit over 2,000 bills. So again, a direct result of having a virtual session. So of those 1,000, they passed about 30% of those bills. So again, a really low number in comparison to years past. But that didn't reduce the work that WSHA staff had to do. So you can see here, in this session, we reviewed 264 bills. So yes, that is a lot, and we certainly felt it. And then the final number I have here is 59 billion. So this is the total of the state budget that legislators passed. This is an unprecedented amount. And a key reason why is because of the historical amount of federal money that is incorporated in the budget. And in a moment, I'll talk more about the state budget. But here you go, some facts and figures to kind of leave you with. Next slide.
And I'll chime in and say I really appreciate Shirley put a slide together with all the numbers. And I think that the piece here is that although there were, lower number of bills, they were, as mentioned, all those themes we talked about earlier, they were really big, systemic, culture shift type of bills. So there's a lot of work being done for sure.
Absolutely. Thank you, Zosia. Next slide. Thank you. So before we do some deep dives into policy issues, we wanted to kind of kick off this session by talking about the budget, because this is an important piece of the government affairs work that the Hospital Association does on behalf of our members and their patients. And before I get into WSHA's budget priorities, I think it's really important to just set the landscape, because this was a very interesting environment that we navigated through this year. So kind of last year, kind of through the summer, into the fall, and actually all the way through the early days of legislative session, we were all preparing for a really grim, a really kind of doom and gloom budget environment. And this is because of the economic impact of the pandemic. If you recall, last year, there were many sectors of the economy that essentially shut down. Some of us were able to work from home, but it was a very different economic space that we were in. And as a result, businesses were paying less business and occupation tax. We were shopping less, so there was less sales tax collection. So really a lot of uncertainty in terms of what kind of hole was this going to create in the state budget. So as we were getting ready for session, we were really in the mindset of, okay, we need to prepare ourselves for, potentially seeing some really deep cuts in the state budget. Nobody, of course, wanted to see a repeat of what we saw 10 years ago during the Great Recession, but that was the space that we were all navigating in. But then something really interesting happened, probably kind of into end of January, February. We saw a dramatic pivot in the state budget landscape. And for those of us that have been doing this for a while, none of us can remember such a dramatic shift. And there are three key reasons why we saw this shift. One is Washington State. We actually recovered quicker from the pandemic than we thought we would. We were actually one of the leaders across the country in how quickly, we bounced back. So it seemed like for those of us that were still employed and were working from home, we were busy buying homes, buying cars, and other big ticket items. Second is there had been a lot of discussion in years past about the state finding new sources of revenue. And there had been many proposals put on the table over the course of the last several years. But this year, more than ever, this gained some new traction. And ultimately, what we saw is the state has passed a new capital gains tax. So this is a tax on the sale of long-term capital assets. And those assets are, above $250,000 per year. So it's estimated that this new tax, when fully implemented, will generate about $500 million per year for the state. So it certainly fills a significant hole in the state budget. And then the third reason is the federal funds that we saw. I mean, there had been conversations last year about, would the feds, provide federal stimulus money to the states, and if so, how much? This became more certain in February and in March. And we have seen an unprecedented amount of federal money come directly to Washington State to help us not just address the pandemic response, but the economic impact of the pandemic. So very different budget landscape that we ultimately got than what we thought we would. So with that, I'm going to turn it over to Zosia, and we'll walk through our WSHA budget priorities.
Yeah, thanks, Shirley. So we usually go into session with budget and policy priorities, proactive items that WSHA will advocate for on behalf of our members, on behalf of patients. One of the big overarching issues we've been focused on for the last probably 4 or 5 years is what we call difficult to discharge patients. So those are patients, I'm sure for any of you who work with or near hospitals, patients who are stuck in acute care hospitals without an acute care need. So maybe they came in with a need to be in a hospital, but they've moved to the point where they need some type of post-acute care, but for some barrier is keeping them in the hospital. And at the beginning of the COVID pandemic, back when the legislature was just ending in 2020, so back in February, March of 2020, we advocated with the legislature to say, look, about 10% of hospital beds across the state were being used by a non-acute patient. And at that point in the pandemic, there was a lot of concern about access to acute care beds. And part of what we advocated for and what the state did was to give additional funding to DSHS for the Medicaid program to increase some of the rates for patients to be able to move into long-term care settings. One of the populations of patients that we see get stuck in hospitals a lot are memory care patients, so patients with a dementia like Alzheimer's, especially if they're a Medicaid patient. It's really challenging to find a post-acute care setting that will accept those patients because they can be really complex. So what the legislature did early in the pandemic was to give a rate bump to the program called Specialized Dementia, to add $60 to that rate. We found that to be really successful in being able to move patients out. So we advocated this session for that rate bump to be permanent, to have that $60 rate bump be something that is included in the state's budget, at least for the next couple of years moving forward. And we were successful, we're really pleased. So we got that $60 rate bump for specialized dementia patients. And that rate bump is just for patients who are moving out of acute care hospitals. So we are very hopeful that will continue to help move patients out into a more appropriate setting, because our hospitals are very good at what they do, but nobody wants to live in a hospital. Nobody wants to be there longer than they need to be. And so it's best for those patients to be able to move out into a specialized setting. In addition to the $60 rate bump for acute care discharges, there's also a $10 rate bump for all patients in any setting for specialized dementia. So really pleased with that funding, and I will flag, and we'll talk about this towards the end of the presentation. We'll continue to advocate on this topic because it's one that continues to be a challenge. So Shirley, I'll turn it back over to you. Oh, sorry, one more, hospital placements. So the other piece of difficult to discharge, as I mentioned, there's a ton of reasons why patients get stuck. The other pieces we're really pleased to see funded are geriatric beds, specialized geriatric services, and then non-citizen beds. So these are slots for patients who need some kind of long-term care placement, but are not eligible for Medicaid because of their citizenship status. It's state-only funding, and they're very expensive. We've been advocating for these beds for a long time, and we're really pleased that this finally got funded. So now over to Shirley.
Thank you. So a long time budget priority for the Hospital Association has been in the area of behavioral health, and specifically around how to increase bed capacity for patients who are on 90 or 180-day civil commitment orders. And this is really important because a few years ago, Washington State announced their intention of closing long-term psychiatric beds at Western State Hospital and moving these patients to community facilities and hospitals in order to be closer to their support system. So it's really important that before any beds close, that we have sufficient bed capacity in the community for these patients. So a big challenge around this has been the Medicaid rate that hospitals get paid to support and care for. Really, it's one of the most vulnerable patient populations in the behavioral health sphere. And so for over 2 years, the Hospital Association has been negotiating with the Healthcare Authority around how to establish a rate methodology so that hospitals are getting paid a rate that is sustainable and feasible. So we were ecstatic this year that our negotiation efforts have paid off. And so a rate methodology that we agreed to and our hospitals are good with is actually incorporated into the state budget and was passed by the legislature. And then also what we saw in the state budget was sufficient money that was appropriated to support the rate methodology too. So we think this is a tremendous step in making sure that hospitals can be able to stand up these beds and care for these vulnerable behavioral mental health patients. So with that, we will switch over to our policy issues. And I'll remind you all again that if you've got questions, please don't be shy. Zosia and I certainly want to take your questions during the presentation. So do ask them in the chat box. And over to you, Zosia.
Yeah, so our legislative priorities, kind of broadly speaking for this session, were and continue to be to ensure that hospitals can continue to be stable institutions to provide care, to ensure that patients maintain coverage and access to care throughout the care continuum, and to maintain the flexibility of hospital operations and prevent burdensome regulations. As Shirley mentioned, the Democrats do control both the House and the Senate in Washington state. And I probably won't be a surprise to many that as the last election, although it didn't alter, in a big way, the balance of power, I think we did see some increasing, I think, liberal, progressive Democrat interest in the legislature. And we see that can lead to some interest in additional regulation and reporting obligations and what we see as administrative burden. So that's an area that we do pay a lot of attention to. So our proactive issues, we'll just move through these briefly. Happy to do a deeper dive in any of these, but these were our top legislative proactive priorities. So the first is about standard of care. And this came from the fact that during the COVID pandemic, especially early on when we were getting hospitals and healthcare providers are getting an array of guidance from state, local, federal entities about, what's the right care for COVID patients. The governor issued a non-urgent, a prohibition on non-urgent medical procedures, meaning that there were delays in some care that would otherwise have been given in a timely manner. There were changes like, we didn't know early on about the benefit of placing patients in prone positions and moving them around. So we did a lot of work to develop a bill that would address the issue of the standard of care during COVID. So our state med-mal statute, this bill was successfully passed to amend the state med-mal statute to say that during COVID, the standard of care would account for that variation in guidance and understanding of where we were in the COVID pandemic. So it's not a full liability protection, but it is an acknowledgement that the standard of care may have been different during different parts of the COVID pandemic. So we're really proud of that bill. Some of the inside baseball on this one, which is interesting, is that we are one of the only states that was successful in getting anything like this in our state statute. And I think no one will be surprised, we don't always see eye to eye with the trial bar, the plaintiff's attorney group in Washington state, which is pretty strong, pretty powerful. But we were able to negotiate this bill with the trial bar and get to agreement with them. And a powerful senator who's the chair of the Senate Law and Justice Committee, Senator Peterson, was willing to work with us on this. And so we got the bill all the way through and signed by the governor. We're really proud of that. The second bill that's also related to COVID is about state law waivers. You're probably aware that in the beginning of the COVID pandemic, both the federal government and the state government waived a whole slew of laws, but we found that the feds were much quicker off the ball to declare, Washington state was obviously in the forefront of COVID, unfortunately, but it took a long time for some of those state law waivers to get put into place, things that were necessary for hospitals and healthcare providers to provide care within this new world. So things like privileging credentialing obligations, the physical environment requirements of hospitals, pharmacy licensure about where your Pyxis machine has to be, entrance and exit requirements. So things, physical environment things, and also licensure things that needed to be, once those laws were waived, hospitals and healthcare providers could be much more nimble and flexible to care for patients. So this is a bill that hopefully none of us will be around to benefit from. This is a future-looking bill. Future people in our positions will benefit from this if there's a future state of emergency that implicates the readiness of the healthcare system to respond to a statewide emergency, the governor will have to quickly look at a core set of laws to waive relating to facility licensure, pharmacy licensure, certificate of need, things like that. So we're really pleased. Again, we hope that none of us have to benefit from this, but for future state of emergency, this would be a really helpful piece. Shirley?
So certificate of need exemption for psych beds. I'll take the next few items here. So a number of years ago, the Hospital Association heard from our members that a key challenge for increasing psychiatric bed capacity was really the onerous certificate of need process. So through extensive negotiations, we managed to get an exemption for hospitals in the situation where they wanted to add psychiatric beds. So this would be voluntary, involuntary psychiatric beds, short-term, long-term. However, the current exemption was set to expire at the end of fiscal year 21. So we managed to get a bill passed, and fortunately it passed pretty easily, that now extends this exemption for another 2 years. So this is certainly a positive step forward as the state is trying to continuously increase psychiatric bed capacity. The next kind of priority is around telemedicine. So one of the results of the pandemic is that we saw a dramatic increase in the use of telemedicine in terms of delivering care to patients. So here in Washington State, telemedicine is defined as real-time interaction through audio video. And so it does exclude when a provider and a patient are talking on the phone, for example. But, we know that, especially among low-income individuals, they don't necessarily have access to a smartphone. Or there are many places in the state where there isn't strong broadband access too. So it's really challenging to have that real-time audio video interaction, but really important to continuously have access to your providers. So we managed to get a bill passed with a lot of stakeholder support that now includes audio only as part of the definition of telemedicine, and services delivered through the telephone will be paid at parity, meaning paid at the same rate as if those services were delivered in person. And then we also had another bill passed. It was Senate Bill 5325. It made some technical changes for behavioral health administrative organizations. I know it's a mouthful, so BHASOs for short. So now it also includes telemedicine for all populations, not just for kids. So those were 4 bills there that Zosia and I have talked about that passed, that crossed the finish line, and we're extremely proud to have accomplished that. So I'll finish this slide by talking about the one priority that unfortunately we weren't able to pull across the finish line, but it doesn't mean that our work is finished here. And this is around the Nurse Licensure Compact. So for those of you that aren't familiar with the Nurse Compact, this is a multi-state agreement that essentially allows a nurse to have a multi-state nursing license. So this means that a nurse who is, for example, licensed in Tennessee can seamlessly work in Montana, for example. And so we all know that this is even before the pandemic, that there is a nursing shortage in Washington State. And there is no simple solution to address that shortage. It is a multifaceted problem with multifaceted solutions to it. However, we strongly believe that if Washington State adopted the Nurse Licensure Compact, this could be a step in the right direction in terms of attracting nurses from out of state to come work in Washington State. So we meaning the Hospital Association, have joined forces with other stakeholders who are also interested in this to try and get the state to adopt the Nurse Licensure Compact. So unfortunately, we weren't successful this year for a multitude of reasons, but we are committed to this issue, and will be bringing this back to the legislature in 2022. So certainly more to come on this, so stay tuned. Next slide.
Well, I'll live to fight another day.
Absolutely. All right, so now doing some deeper dives into our policy issues, and I'm going to kick this off by talking about House Bill 1148. And this bill is important to highlight because what it does is it increases the Department of Health's ability to oversee acute care hospitals and increases the number of enforcement tools they have at their disposal if there's a situation where an acute care hospital is non-compliant. So I'm going to just start by just mentioning a couple of background points, because it's important to know how we got here. So in 2020, so the last legislative session, a very similar bill passed that impacts freestanding psychiatric hospitals, because there were some concerns that the state and especially the governor's office had about some patient safety and quality issues at freestanding psychiatric hospitals. So the Hospital Association spent a lot of time with the Department of Health, with the bill sponsors, and with our psychiatric hospital members to negotiate the framework of that bill. And so while we knew that we couldn't defeat the bill, we wanted to make sure that this bill was workable for hospitals while still meeting the state's needs. And so what we have this year is a very similar bill that now is applicable to acute care hospitals. So what are some of these new enforcement tools and oversight that are now subject to acute care hospitals? So if there is a situation where the department finds that a hospital is non-compliant, they now have a range of tools that they can utilize. So this includes putting conditions on a hospital license, the ability to impose civil fines, and there are limits of how much those fines can be. If there is a situation where the department finds, and in this case, it also has to be signed off by the Secretary of Health or his or her designee, where there is a finding of immediate jeopardy, and that is defined per CMS, the department can impose a limited stop placement or a stop placement order. And if that is the case too, a hospital does have the ability, either one, to correct it within 5 days or however many days it needs, or if they absolutely disagree, there is a pretty substantial appeals process, including that they can utilize too. And that was something that WSHA worked really hard to establish when we were negotiating the bill last year for the psychiatric hospitals. And then, of course, their current enforcement tool of imposing to suspending a license, to revoking it, or choosing not to renew it. So this bill has passed, and we will be sending out more information to hospitals about the additional details in this bill. Another thing to keep in mind too is that the Department of Health licensing structure, it is required to be self-sustaining, meaning it has to be supported by the fees that they impose on those entities that are regulating, including acute care hospitals. So do anticipate an increase in your bed licensing fees at some point in the immediate future to support these additional oversight responsibilities that the Department of Health has. The acute care hospitals just experienced this, and we are also now working on some rulemaking to implement some of the pieces of the bill that was passed last year. So more to come on this, but we definitely wanted to highlight this for you all during this presentation. Next slide.
Yeah, so I'll talk about some of the worker protection bills. I think not surprisingly, there was a lot of interest in worker protection coming out of the experiences during COVID. There was a lot of interest, and I will say the kind of the inside baseball is that the labor is a pretty powerful force in Olympia. So there was a lot of interest from labor and from employee groups to have more protections for workers during a pandemic or an infectious disease outbreak. So 2 bills to highlight here. Both of them address things like unemployment, presumptions of unemployment compensation, things like that. So the first one is, and that just in case you're wondering, ESSB, this is so SB and HB are Senate bill and House bill, and this is engrossed substitute Senate bill is what that means. So we put these up because these indicate which version of the bill passed. So in case you're wondering about the inside baseball there. So 5190 is the healthcare worker presumptions bill. The legislation has two main parts, and the focus of the bill is entirely on healthcare workers, which is a defined term in the bill. So the first thing it does is it establishes a new unemployment insurance benefit for certain healthcare workers who enter quarantine, who either acquire a condition or enter quarantine subject to a state of emergency or declared emergency. And two, it creates in statute a prima facie presumption of occupational disease for healthcare workers under the workers' compensation program. I will flag that there's obviously a ton of detail here in workers' compensation structure that I think a lot of us will continue to pay a lot of attention to, because this has some really long-lasting implications. In this bill, the UI section includes a new limited pathway for healthcare workers who have had contact with a patient to leave work to go into quarantine. We did a lot of negotiation on this bill, on some of the language to narrow the period of quarantine to the amount recommended by CDC or the direction of state and local public health. We think that most hospitals have already made these kind of accommodations, but it is interesting that this is now part of state law. The second provision in the bill, it's interesting, is for hospitals and health systems is the workers' comp presumption. The presumption is pretty high. It's a rebuttable standard. It is a clear and convincing standard, which is we advocated to reduce to a lower standard, but we were unsuccessful. And again, I think that is in part because labor is very powerful in Olympia. The other bill is the Health Emergency Labor Standards Act, HELSA 5115. This was a huge omnibus bill when it was first provided during session. The first language, it addressed a ton of different things. The bill went through a lot of sausage making in Olympia. That's, the kind of behind the scenes negotiations and things. So what came out in the end, what passed, is three main sections. One is a prima facie presumption of occupational disease for frontline employees. And that is a defined term that is different than the healthcare workers. It applies to more types of workers, but some of whom could be working in hospitals and healthcare settings. Second, it requires reporting to the Department of Labor and Industries by employers with more than 50 workers at a work site, as well as it codifies protections for employees who are considered high risk. We did a lot of work on this bill and the other bill to make sure that the reporting obligations were reasonable and aligned. Like, hospitals already report infectious diseases and other acquired conditions to the Department of Health. And we felt that was the right approach versus L&I, which is a different state agency, different expertise. The other piece under health is there is an obligation for employee notification provisions, so notice about the condition, acquired notifiable conditions or a spread of a condition within the facility. So in HELSA, it's, again, that the standard rebuttable standard is a little bit different. And so I want to flag both of these if you are getting into a workers' comp issue. And again, these are mostly within the context of a state of emergency. So gosh, we hope that this state of emergency will, that we'll get to a point where we can end it soon and we maybe won't have to be focused on this for a while, but want to flag that these will be areas of the law to pay attention to in the future if the state of emergency, if one comes back or this one continues. So we also want to, we'll note that these laws went into effect immediately. They had an emergency clause, meaning that they went into effect right as soon as the governor signed them, which he did pretty early on. So we do on our website, on the WSHA website, we have an implementation guide where we are posting bulletins and guidance for hospitals. But because these laws apply to more than just hospitals, even if you work for another type of healthcare facility, it might be worth reviewing just to see what these pieces are, because because it's an emergency clause went into effect now, and we are in a state of emergency, some of these provisions will affect you now. All right. Again, happy to answer questions if anybody has them. I know that this is a deep level of detail in some of these. Back to Shirley.
Behavioral health. So I'll start this slide by saying we could easily do an entire webinar on just behavioral health issues. So given the limited time we have, I will not do that for you all. But what I will do is just kind of hit some of the highlights that I think would be of interest to you all. And I'll also just reiterate the point that Zosia just made, is that we do have implementation bulletins on these issues. So if there's anything that I'm talking about that you're interested in and wanting to know more details, please do visit the WSHA website and take a look at the bulletins for more information there. So with that, let me start by saying there was a lot that happened this legislative session around behavioral health. And so just a few bills here that we wanted to highlight for you. So one was around increasing patient access to opioid reversal medication. So this is Senate Bill 5195. So the purpose of this is to just really make the availability of drugs like naloxone more readily available, including the ability of patients not necessarily to take those drugs in a hospital setting, but the ability to take those drugs and take them at home. There was also updates to the mental health directive, that's Senate Bill 5370. So some of the changes include allowing children and youth, so age 13 through 17, to utilize a mental health directive, and also the ability of a notary to execute that. So of course, we can't have a legislative session without some changes to the Involuntary Treatment Act, which if you're not familiar with it, this is an enormous statute that we have on the books. So again, we do have a bulletin that goes into more details, but for example, some of the changes we have are around, patients who are in crisis and are veterans. So if they are engaging with a designated crisis responder, that DCR does have the ability, if the veteran does consent, to direct them to VA services rather than an acute care hospital. And then there are also changes to Ricky's Law and the use of less restrictive orders there. So again, do refer to the implementation bulletin for more details. So those were the kind of the bucket of bills that have a direct impact on hospital practices. There are also a couple of bills which, looking on the horizon, we will know that will have future impacts on hospitals. So one is right now we have kind of regional behavioral health ombuds offices. Those are going away and being replaced by a statewide office. And so there'll be more work to come in terms of what that will look like. There is also work being done around a crisis line. So this is in response to the federal government setting up 988 as the federal crisis line. So there's a lot of interest in Washington State to utilize that, and how can we kind of take that as a starting point to really kind of look at how crisis services are delivered in this state. So there will be a lot of work being done during the interim in terms of what that would look like, and then what are the next steps for the 2022 legislative session. So again, more to come on behavioral health, but those are the kind of the key items we wanted to highlight for you today. So with that, next slide. Thank you.
Yeah, so I'll briefly talk about, there's a very significant bill for hospitals called the House Bill 1272. It's on hospital financial transparency, but it also has a number of obligations that tie to the overarching theme and interest in the legislature this year and in society generally about equity and disparities and access to care, and are we serving the populations of our various populations of our state well. So I have 2 slides on this. I'll go through them pretty quickly, but I wanted to make you all aware of this because these are some new obligations that hospitals will need to be aware of. So one is a new financial reporting obligation. Hospitals already report to the Department of Health on a quarterly and a yearly basis. And there's a new obligation starting in 2023 to have a more granular level of reporting about other direct expenses and other direct revenues, and also reporting of expenses, revenues that are above a certain threshold if they're not otherwise reported. And I will say that gets into a real level of granularity about financial reporting that I happily don't have to live very closely with, but your finance folks will probably be very aware of this because it will require a new kind of accounting and reporting mandate. The other piece that is very new and I think will be interesting to see how the department issues rules on is there's a new obligation if for any health system that operates an acute care hospital in Washington state, that health system has to submit a consolidated financial report and a balance sheet for other types of healthcare entities that health system operates in Washington state. There's a whole list of those other types of health entities. There are things like ambulatory surgical facilities, clinics, physician groups, labs. Got it. David, I can hear you briefly. I'm not sure if you have a question. Okay. We'll chat or chime in if there are questions. Anyway, this is a new obligation. There are a couple other states that have done this as a system-based reporting obligation. But if you're part of a system, an entity that operates a hospital plus other types of entities, this will be a new obligation. There's also new patient demographic collection and reporting obligations. So this will require updates of electronic health records. These will be things like race, ethnicity, gender identity, sexual orientation, preferred language, disability. The department will be doing rulemaking on this. The rulemaking should be done by July of 2022, and then hospitals have to comply by 2023. So just know that there'll be much more from us on this because this is a big change for the type of information hospitals have to gather and report. I will note that we were able to get language in the bill that says that the hospital obligation exists, but it is voluntary for patients if they want to provide the information. And hospitals will not be penalized if they don't report the information because the patient chooses not to share the information with the hospital. We were also able to get some dispensation for very small hospitals who will have a really hard time updating their EHR system. So if you're part of a small hospital, a critical access hospital, et cetera, there are some special exceptions for you that the department will create rules on in the coming months. There's also a new obligation to do quarterly reporting of new data on charity care. So currently charity care data is reported in kind of the amount of charity care provided. The new obligations are to submit the number of submitted and completed and approved charity care applications. So that I think will be very interesting. That's a new type of information we haven't had previously in Washington state. If you are a hospital or system that has provider-based clinics, be aware that the definition has changed and that the impact of that change of definition means that there will be more types of facilities that have to report data under the provider-based clinic statute to the Department of Health. There is a study the University of Washington School of Nursing is leading on hospital staffing, which will be very interesting. My guess would be that depending on the outcome of that study, it is possible we may see the nursing unions propose nurse ratio legislation in the coming years. So we're keeping an eye on that. And then last but not least, there is new obligation for nonprofit hospitals, so federal 501c3 hospitals, which have an obligation under federal 501R law to do community health needs assessments. There's a new obligation for submitting your CHNA to the Department of Health annually, and a new obligation to submit some very detailed information to the Department of Health each year on community health improvement services. So lots more to come there. There's a ton within this one bill. And access to care, I'll just note a couple of these that are important. So sexual assault survivors, there have been a series of laws over the last couple of years that WSHA has been very supportive of to expand access and support for sexual assault survivors. This year, the pieces to be aware of, there was a new obligation for hospitals to provide a notice of benefits to survivors, which the It's the Office of Crime Victims Compensation will develop. But there's a new obligation to give the notice, and then also to have a right of referral, which is a term that's used in the statute, not defined, but basically a right for the survivor who is at the hospital to get connected with a community support system, as community sexual assault program. The other bill to be aware of is the miscarriage management bill. This is a bill that prohibits healthcare entities from telling healthcare providers that they cannot provide services necessary to support a patient who is experiencing complications related to pregnancy. This is a bill that we've seen for the last couple of years. It is aimed at Catholic healthcare, but for constitutional reasons, you can't write in law something that distinguishes or that regulates a hospital based on its religious affiliation. So this is a broad bill, but it really is aimed at access to reproductive services, miscarriage management, things of that sort. I will note that WSHA opposed this bill because it has a private cause of action that's very expansive, meaning that there's the ability of a provider, a patient, or a third party to bring an action against a hospital if there is an allegation the hospital has, or the healthcare entity, broader than hospital, has violated the law. Again, there'll be more guidance from WSHA on that bill as well. And then last but not least, non-fatal strangulation. Washington State is the first state to put into law access to forensic nurse examiners, so the SANEs, the same types of folks who do the sexual assault exams. Access to SANEs for people who have suffered non-fatal strangulation. This was a pretty widely supported bill. There's a lot of evidence that patients who show up with non-fatal strangulation often will have experienced other types of abuse, either coinciding with strangulation or elsewhere. And that forensic evidence collection is helpful if there is a future case, criminal or civil, regarding that patient. So just know that there's a new access for those patients to SANEs, and the Crime Victims Compensation Fund will cover the payment for that service. And I think this is maybe the last of my series of slides. Just a couple other pieces that fit under access to care. There's some changes in medical assistant supervision laws. There's a change in the pharmacy compounding obligations, what qualifies as compounding and what doesn't. We were supportive of it, as well as the Pharmacy Commission. There was a nurse delegation bill that died. That bill, I can't recall if this one was highly contentious, but a number of kind of delegation and scope of practice bills are pretty contentious in Olympia when you're touching the scope of practices. It bumps up against other scopes. And then there's a bill around telemedicine consultation. As Shirley mentioned earlier, there's a ton of interest in telemedicine this year, as we've seen many more people access care via telemedicine options. And this is, forgot about this one. This is another one that is really an interesting one that I worked on pretty closely. This is our informed consent statute, 770.065, so RCW 7.70.065. This is an interesting one because there was an unintended error in the 2020 session. There was a big omnibus bill that addressed the uniform guardianship law that goes into effect in 2022. And that bill had passed 2 or 3 years ago, and there were a series of kind of trailer bills that were, cleaning up identified issues in prior bills. And in 2020, one of those cleanup bills amended the informed consent statute such that it just didn't make sense anymore. They just took out whole words and phrases. And the sponsor of the bill, who again, Senator Peterson, who's the chair of the Law and Justice Committee in the Senate, acknowledged that this is he had sponsored the bill that made the error. So he was really proactive and reached out and said, I've identified this problem, and can you work with me to help amend the informed consent statute to fix the issues? So we fixed the errors, that we put back the words that were missing, but we also, I think it's a really good step. Right, currently in the informed consent statute is a structure where it talks about competence and a court decision, when in fact, it's really, in the legal side, it's about capacity and a medical decision. So we added a definition of capacity, which is new in that statute. And we did maintain the rest of the structure of that statute. So this will come into play if you all are ever thinking about, surrogate decision-making, informed consent, looking for decision makers for patients. This statute is a one that we pay a lot of attention to because it's very important for the care provided to patients. The other one to just be aware of is there was another proposal that was the trusted decision maker, it was called trusted decision maker concept, and it would have added a new decision maker into the surrogate decision maker list of hierarchy. That one didn't pass, but I think it will continue to be an area of interest because we see more patients who have not executed a power of attorney, they don't have a decision maker, and it's challenging sometimes to find a decision maker for them. Over to Shirley.
All right, thank you, Zosia. So if you recall, earlier in this presentation, I mentioned that one of the key themes of the legislature was to really address issues related to health inequity. So as a result, we saw a number of bills and budget issues around this very topic. So on this slide, we wanted to highlight for you some of the bills and policy issues that WSHA supported in particular. So I'll just walk through each of them very briefly. So Medicaid postpartum coverage. So there are a certain population of women who qualify for Medicaid because they're pregnant, and when they do qualify for Medicaid in this condition, their coverage extends through their pregnancy and then 60 days postpartum. And so there have been a group of advocates for many years that were advocating that 60 days postpartum isn't sufficient, especially if you want to move the needle on maternal health issues. So the passage of this bill means that for women who qualify for Medicaid under this category, they now have their Medicaid coverage extended 12 months postpartum. And so not only does this help them access medical care, but also behavioral health care too. So a very big win for advocates. And again, this is an issue that WSHA did support too, because it's one additional way to increase access to care. Senate Bill 5313 is around health insurance discrimination. And specifically what this means is that health plans can no longer deny patients who need gender affirming procedures and surgeries that are medically prescribed. Subsidies for health insurance coverage, 5377. So for individuals who are accessing coverage on the health benefit exchange, so they are individuals who make too much money for Medicaid or don't have employer-sponsored coverage and are looking to purchase their own coverage, they generally go to the exchange. And so for low-income individuals, so it's defined as those that make 250% of federal poverty or less, there is now the ability for them to access additional subsidies. So these subsidies will kick in 2023. And the reason why is that for 2021, so for this year and for next year, through the federal bill that passed around COVID relief, the American Rescue Plan Act, there are very generous subsidies, but they only are for 2 years. So once that ends, these state subsidies will then kick in. And so hopefully, we'll see more participation and interest in coverage for especially low-income individuals on the exchange. Now, in the budget, we saw there was $35 million that are going to rural health clinics, community health centers, and free clinics to help them cover the cost of caring for individuals regardless of their immigration status. And then finally, another issue that WSHA supported is $50,000 for the Healthcare Authority to do a study about whether or not to include medical and psychiatric respite as a Medicaid benefit for unsheltered individuals. So really, these are folks who they no longer meet admissions criteria in a hospital, but once they're discharged, they don't have a stable home to go to. And that really does impact their ability to recover from whatever illness or injury that brought them into the hospital. So we'll be paying close attention to that study and definitely want to see this included as a Medicaid benefit. So next slide. And then, of course, public health and COVID-19 response, a central theme to what we saw in terms of interest and action in Olympia. So a few things to highlight for you here is one of the things we're going to see are new comprehensive public health districts. So just kind of a reevaluation of the current ones. There will be a new public health advisory board, and also the ability for these public health districts to include more non-elected members. So really the focus was to get more subject matter experts to be on these public health boards as opposed to just elected officials. There was also a lot of interest in a bill that was introduced but did not pass around foundational public health. And that is because for many years, public health has been grossly underfunded. The reason why this bill didn't pass is because of the next bullet, is that we saw, as I've mentioned before, a really significant amount of federal money come to Washington State to help with the pandemic response. So, House Bill 1201 and Senate Bill 5149, which is the companion bill, wasn't necessarily needed this year. So one of the key things to remember in terms of the federal money, we've seen about 1.5 billion, that's correct, that's billion with a B, of federal funds to help support efforts like vaccine deployment, the recruitment of public health workers to help with contact tracing and testing. And then saw $147 million of state money to go and to support foundational public health. So hence, that's why a new tax wasn't necessarily needed to support public health services, because there was money found in the state budget. And then next slide. Thank you. So what Zosia and I have tried to do during this presentation is to highlight for you our WSHA priorities and other bills that were of key importance to our members and the patients we serve. But that is certainly not the only bills that we looked at this session. If you recall one of my earlier fun facts, it was 264 bills that WSHA staff looked at. So that includes many other bills that we did not talk about during this presentation. And they're in a multitude of areas that touch healthcare and patient care. So that includes issues around the environment, consumer protections, and other issues there. So one thing I want to highlight for you, if you are at all interested in some of these other bills, please do visit the WSHA website. One of the things WSHA does during legislative session is we have a publication called Inside Olympia. It goes out every week to folks that subscribe to it. And in that publication, we not only talk about our priority bills, but all of the other bills that we think are of interest to our members. So wanted to highlight that for you all during our presentation. Next slide. All right, yes, I know we have talked about a tremendous amount of bills and budget issues that we worked on this year. And if you think that that's the end of our work, unfortunately, you are wrong. This just means now that session is over, our work just pivots, and it pivots in a few different ways, which I will highlight for you. So one is, while the work at the legislature is done for this year, many bills now require regulations to be either amended or created. We call this rulemaking. So for example, early on in the presentation, I talked to you about House Bill 1148. This is the bill that expands the Department of Health oversight of acute care hospitals. So part of that bill requires the Department of Health to do some rulemaking about what that civil fine structure will look like. So that's just one example of the rulemaking work that is now the focus of WSHA Government Affairs staff. So there'll be more to come on this. The other kind of piece of work is around, we've titled it here, bills that are still alive. And this is just a result of the way our legislature is constructed. So we look at while session happens every year, we really look at it as a 2-year cycle. So 2021 was the first of the 2-year cycle. So for the bills that didn't quite make it across the finish line this year, unfortunately, for the ones that we didn't like, that doesn't mean that they are dead and forever gone into the netherworld. They could pop up next year too. So we have to continuously pay attention to, what's being said, conversations that are happening during the interim, and, is there a possibility that we will be revisiting these bills in 2022? Now, for the bills that we do support and didn't quite make it across the finish line, for example, Nurse Compact, that is good news. But again, we got to balance it with those bills that we didn't necessarily like and would like to see an end to that. So here is just an illustrative list of some of the bills that we will be watching to see what happens in 2022. And then, of course, potential issues for 2022. I already mentioned the Nurse Compact. but there are other ones that a lot of work needs to be done during the interim to get those issues ready for the next year. So that's just a high level overview. Zosia, I don't know if there's anything you wanted to add to that list, but just kind of giving you a sample of our work to come.
Yeah, the one I'll flag is, and it ties to the transparency bill I talked about earlier. I think there's continuing interest in healthcare transactions and the overall cost of healthcare. And part of the challenge of that is that the drivers of those things are often national federal issues that are challenging to deal with at the state level, but there's still a lot of interest in those topics. So I would say we are not lacking in interesting topics to wrestle with for the coming years.
That is certainly true. All right, and then our last slide to wrap up our presentation is that we don't want this to be a one and done interaction with the work that we're doing. We highly encourage you, if you are all interested in the government affairs work that the Hospital Association does, there are certainly many ways for you to stay informed and engage in the work that we're doing. So a moment ago, I mentioned Inside Olympia. That is just one of the many newsletters that we put out during the year. If you are interested in subscribing to Inside Olympia or Weekly, which comes out all during the year on a weekly basis, or there's Fiscal Watch or Inside DC, which focuses on federal issues, please do visit the WSHA website and subscribe to one or all of these newsletters. And then, of course, we are now busy drafting and releasing implementation bulletins on the key bills and budget issues that passed this year. There's also the ability to follow us on social media. We are on LinkedIn, we are on Facebook. You can keep tabs on the work and the issues that we're interested in. And then, of course, if you want to be more involved in the advocacy work that we're doing, please do sign up to be a hospital advocate. And you can access all of this using the address we have there on the website. And with that, I encourage you, if you have questions, please ask them, or if you think about questions after this presentation, we have included our contact information. We love talking about this stuff, so please don't be shy in reaching out if you have any questions or comments about what we've talked about or the work that we do.
And thank you all. Thank you for having us. And again, we're always happy to do deeper dives in any of these topics. And if you've, as Shirley mentioned, if you've identified any challenges that you think could be addressed at the legislative level, please reach out to us. This is the time of year where we are starting to think about that.
Wow. Well, thank you, Zosia and Shirley. You just provided us some wonderful examples of how the pandemic really created an environment of resilience for both of you. I know every year you're busy, but I think this is remarkable, the amount of things you've been able to accomplish and what you're looking forward to doing. I think many of us feel like we're working harder now than we ever have, and clearly both of you are. Want to thank you very much for all that you do for us, trying to keep our citizens safe in the state of Washington, and working diligently with our providers and legislators to make sure safety is a prime concern and that we're moving in the right direction. So thank you very much for presenting again. We always appreciate hearing from you. And again, thank you for all you do.
Thank you.
Thank you. Okay,
I think we are staying pretty well on schedule. So I'm going to go ahead and introduce our next speaker. The next topic is a marketplace update, claim severity and industry trends, that will be presented by Claudette Kenmir. She is the Vice President of Business Development with Physicians Insurance. PI is the largest professional liability insurer in Washington for doctors and hospitals. Claudette is responsible for PI's broker distribution channel and has more than 30 years of insurance industry experience in sales, marketing, and underwriting. On a personal note, she is an avid alpine skier and outdoor enthusiast. Welcome, Claudette, and thank you for joining us today.
Thanks, Michelle. It's nice to be here. I appreciate that. Can you see my screen?
Yes, I can see it. Thank you.
Okay, great. Thanks for having us here. I also have two of my team members online, Maria Byers and Nancy Reitar. They're both senior business development and partner managers at PI, and they're going to be monitoring the chat in case we have time for questions at the end. Today, we're going to talk about the medical professional liability insurance marketplace, claim severity, and industry trends that are impacting your MPL premiums. We put this presentation together last year, so if you know that some of the slides might have a little dated information, we're in the process of updating that, but I can tell you in this line of insurance, the trends don't change very quickly. So let's jump into it. In 2014, we had a 16-year-old woman who was 25 weeks pregnant, and she was hospitalized with severe preeclampsia, which, as you guys know, is a serious complication characterized by high blood pressure. Her physicians contend that they advised her to undergo an emergency C-section, and she refused because she heard them say that the baby would die or be severely brain damaged. So a few days later, she did deliver her baby vaginally, and it was distressed. A few years after that, she filed a lawsuit. And after the parties rested, after 2.5 hours of deliberation, the jurors gave a verdict to the plaintiff of $229 million, which was shocking. And this was a PI case. It was the largest medical malpractice verdict ever recorded. So as you can imagine, the case has gone through the appeals process in the Court of Appeals. The verdict was overturned just recently. They found that there was clear evidence that the patient was fully informed multiple times about having a C-section and delivering this baby vaginally. And the doctors had told her what would happen. And unfortunately, it did happen. The reason that I'm sharing this with you is it's a great example of the efforts that jurors will go through to help someone in a sad situation. But it didn't matter that the evidence had said the providers were in the right place and had done the right thing. So our agenda for today is we're going to talk about the market conditions impacting rates. We're going to talk about increasing frequency of severe claims and what impacts that, overall impacts to the MPL industry, rate actions, and then at the end, if we have time and you have questions, we'll be happy to address that. We know that healthcare has changed dramatically over the last few years with electronic medical records, increased technology, changes in reimbursements. But one of the major things that's changed the MPL industry is the shift towards consolidation of physicians moving to employment at hospitals or large groups. As you can see from this chart, from 2014 to 2018, 35,000 independent practices nationally were acquired by hospitals. That's significant. So with physician consolidation occurring, many carriers had to decide what could they do to increase their revenue source. And they moved to different geographic locations. They were providing different products. In the Pacific Northwest, where PI does the majority of their business, we saw 36 new entrants between 2010 and 2020. That's a lot of new carriers. It's a lot of new competition. And the impact of that is that it drives prices down. And it happened during a soft market while prices were going down and frequency of these large claims like we just talked about were going up. So let's talk about what is a soft market. I know several of you on this virtual conference are insurance people, so you totally understand this, but I thought I would level set everyone. The insurance industry is kind of predictable. We go through a cycle. We go through a soft market, and then we go into a hard market. It's always a crystal ball, how long we're going to be in each, we never know, but it always happens. So a soft market is identified by easier underwriting by your underwriters, increased capacity in the marketplace. There's more competitors in the market, as we just talked about, those 36 new entrants. That drives the premiums down, and carriers will often increase the coverages that they're willing to provide to the healthcare systems. Then we go into a hard market, and a hard market is characterized by tougher underwriting, reduced capacity, fewer competitors. During these hard markets, we will see carriers leave states or leave the product line. That drives up premiums, and carriers will often restrict coverage that they're willing to offer. Until very recently, the MPL marketplace had been in a prolonged soft market with ample carriers in the marketplace. But as we move into this next phase, we want to illustrate the market conditions, how they're changing, and the historical impact of the combined ratios. Some of you I know this inside and out, but again, I want to level set the group. Combined ratio is used as a financial measurement in the insurance industry, and it really is looking at the cost of doing business for an insurance company, covering claims, the loss adjustment expense, plus the underwriting expenses. And the underwriting expenses, think of those as the cost to run the company. So you add up all of that and you divide it by the net earned premium. If you're lucky, you'll come up with a combined ratio of under 100%. That means you have an underwriting profit. If you have a combined ratio over 100, then you've got an underwriting loss. So think about if you give me $100 for premium and I have a combined ratio of 90%, that's great. I have another $10 that I can invest in the company or invest in services to my customers. On the other hand, if you give me $100 and my combined ratio is 110, I'm using what you gave me to cover costs plus an additional amount of money out of the surplus of the company. So let's look at a historical analysis of the industry. This shows combined ratios from all the way back to 1978 to projected 2020. And you'll see a black line across the 100% mark. The red graphs are correlating with a hard market and combined ratios of over 100%. The green bars represent the soft market and a combined ratio of under 100%. So from 1995 to 2001, you can see we were in a hard market. The combined ratios were over 100%. But because the interest rates were higher, carriers were able to get investment income to offset those increased costs. In about 2001, interest rates dropped and companies were pulling out of the market when that happened. After that, we went into a soft market, an extended soft market from 26 to 2016. At the same time, premiums were going down. We shared with you that lots of competitors were coming into the marketplace and frequency and severity of claims had stabilized. However, that gave away after all these carriers came in, prices dropped, we went back into the cycle. In 2016, we started right back into the next hard market. It's very cyclical. This next slide shows the average of the top 50 medical malpractice verdicts in the US. And I want you to look at the red bars in this graph. In 2002, the average verdict was $20 million or greater. It took another 10 years to 2012 before that happened again. And then 6 years later, in 2018, the average verdict was at almost $30 million. And in 2019, it went down to 27 million. So you can see the frequency of these severe claims is increasing. This graph, since 1991 to 2019, shows the average paid indemnity. And personally, it's an ugly graph. What it shows is the average indemnity for claims has gone up to $425,000. And this doesn't include the cost to defend claims. It's just the average indemnity. And like I said, it's not a good looking graph. Speaking of the cost to defend claims, so you have average indemnity at $425,000. You have factors that are increasing the cost to defend claims. From 2007 to 2019, you'll see this graph, and the cost just to defend the claim has increased 50%. And for any attorneys that are out there, you also know that a lot of these claims are much more complex to defend than they have been in the past. So the ladies from WSHA, you guys are doing such great work, and it just makes me tired to think of everything that happened in this most recent legislation session. But great job. What I want to do here is show some of the historical legislative issues that we've had in Washington. There's been in the Pacific Northwest, there's really been no meaningful liability reform, and it's eroded over the years. We've seen abuses in the civil justice system with things like venue shopping, junk science being allowed in the courtroom. In Washington, there's been a brief time where we had a cap on non-economic damages. This, for non-economic damages such as pain and suffering and non-monetary losses. Economic damages, to be certain, are not capped, and we don't recommend that they are capped. But Washington also used to require that plaintiffs file a certificate of merit and a 90-day notice of intent before they filed a suit. That was declared unconstitutional by the court decisions. This next item, SB 5163, in 2019, Washington opened a new class of beneficiaries in wrongful death cases. They said that parents and siblings of deceased parties are eligible to bring suit, whether they live in the US or they were financially dependent on the deceased. And for those of you who were around a few years ago, you might remember the duck accident that happened in Seattle, and this legislation came out of that accident. Washington also has joint and several liability, where a defendant who might be only minimally liable for harm can be required to pay for the entire judgment if a co-defendant is unable to pay. So why is that an issue? The impact of this rule is that parties that otherwise might contest their minimal liability may look to instead settle so that they don't get stuck with a large verdict at the end. I've included a few things from Oregon too, because I think maybe some of you on the call are borderline Washington and Oregon. So in Oregon, there is a no collateral source rule where the plaintiff can show the jury the billed medical expenses rather than the amount that's actually paid or required to be paid. And all of us know that the billed amount is going to be significantly larger than what is actually required to be paid. And that's known as phantom damages. Loss of chance of a better outcome. This is something that we already have in Washington, but it's recently come up in Oregon. And this allows patients to claim damages if they had a chance of a better outcome. So with COVID, we don't know how that's going to impact this, because we all know that many patients stopped going to their doctor for a while or delayed surgeries for a while. So we are watching the impact of this one. The last one is the $500,000 non-economic damage cap. This has been heavily contested over the years. I just talked to our lobbyist, Ann Bryant, yesterday, and she said the cap is still in place. And actually, today or next week, there's a bill in the Oregon legislation that they're going to clarify the cap is at $500,000. So more to come if you're interested in that in Oregon. Another fact that's contributing to increasing claims costs is social inflation. And I don't know about the rest of you, but I didn't even know about this term until a couple of years ago. It's utilized in the insurance industry, and it really talks about loss costs are being driven up by shifts in distrust of corporations, the composition of the juries, and some effective plaintiff attorney strategies, and we'll get into all of those. One significant trend is the distrust of corporations, and it got worse after the financial collapse of 2008. Since that time, there's been a greater division and separation of wealth and a feeling that someone has to pay when things go wrong. The shift in mentality makes it easier for a jury to believe that that faceless corporation that has the big insurance policy with ample assets, they should be held responsible. And plaintiff attorneys are using this distrust too. We've seen it in cases in Washington where they don't name the provider in the lawsuit, but they name the entity. And I truly believe that most people like their doctors, and it's easier for them to file a lawsuit against the corporate entity versus their own individual provider. And then social inflation is impacted by the people who are serving as jurors. As the millennial generation becomes jurors, their experiences and their mindsets are different than other generations. Most millennials entered the workforce during the last economic recession. They were saddled with student debt. According to trial consultants Mind Matters that we use for many of our cases, millennials are starting to take leadership roles in the juries. And the plaintiff attorneys who want the jurors to send a message, i.e. big verdicts, out there are playing to that social responsibility mindset. Additionally, younger generations are increasingly less trusting of authority. The Pew Research Center conducted a study analyzing the differences in opinions by generations. And what they found was 73% of the adults under 30 believe that people just look out for themselves, versus 48% of the baby boomer counterparts who believe the opposite. The same study also found that younger Americans are less likely to have confidence that key institutions, such as the military, religious leaders, and the police, they just don't have confidence in all of those. And we're seeing that playing out in today's society. All of this plays into how a jury might perceive the care being given to patients and impact their decisions when they render verdicts. I think the older generations might assume that hospitals and healthcare workers might do the right thing, but the younger generation is more skeptical. Jurors of all ages today, I think, might be basing larger awards on the skewed value of the dollar and the uncertainty of access to medical insurance. Prior to 2016, the public had some comfort that medical insurance would be available through the ACA or private insurers. That might not be as strong as it was. And many people, including myself, are on high deductible plans. So the jury may be thinking a little differently, that they want to make sure that the plaintiff who's been injured has health care going forward. The other thing that impacts the value of the dollar is skyrocketing rent and home prices in our core market. I'm based in Spokane, Washington, and I'm hearing on the news that rent's going up over 20%. Houses are going up, selling for way over their asking price. And I know in Seattle, Portland, it's even more drastic than it is over here. But these jurors are looking at that, plus the knowledge of income that professional athletes and celebrities and influencers are making, and it really is impacting what they think is a fair verdict for these plaintiffs. Another contributing factor, and it was nice to hear from the WSHA folks that they had some success with the plaintiff bar in this last legislative session. The plaintiff bar is highly organized in a very collaborative group, and they often share success strategies with each other, one being the reptile theory. And the reptile theory is an attempt to reach that primitive part of the juror's brain that thinks about safety and survival. And they use an argument that the defendant's care was unsafe. And so you have to do something and make the defendant responsible because of that. There's a plaintiff bar or plaintiff attorney office who's big into the reptile theory. And this photo, which I think is kind of hokey, was on their website. And they promote manuals about the reptile theory, and they provide seminars. And according to them, 7.7 billion can be attributed to verdicts and settlements that use the reptile theory. And you can see at the bottom of that slide, it says the most powerful tool in the fight against tort reform. It's an interesting theory. The plaintiffs and the plaintiff attorneys have another tool that they can use, and that's litigation financing. It's where they go to a third-party funder in exchange for an interest in the potential verdict that they'll get. The agreements are usually non-recourse, so if the plaintiff loses a case, the funder doesn't get anything. The consequence of this, though, is there's more money for these cases, and especially the weak ones, that they're willing to take them to trial. It prolongs the litigation and it discourages settlement because they really believe at the end of this, they're going to get a big verdict. For the plaintiff, they really have to think about the settlement and what they want, because they're going to have to pay part of that verdict, not only to their attorney, which they have done in the past, but also to this third-party funder. So we see this growing. It's unregulated except for the 4 states that are listed on your screen, but we don't think this is going away. We'll see more of this going forward. Aside from the things that we've talked about, we're all living through the uncertainty of COVID-19, this pandemic, and I pray that none of us ever go through this again in our lifetime. So we really appreciate those of you who are in the conference who are providing healthcare to your patients. You had to constantly change the way you were delivering healthcare, and we so appreciate that. The thing about COVID-19, it's a new risk, and with any new risk, we don't really know what the impact is going to be on the insurance industry, but we are tracking a few claim trends from COVID-19 that I want to share with you. For medical malpractice, we're monitoring claims related to community spread or delay in treatment or deferred non-essential care. To note, the delay in diagnosis and treatment was an issue pre-COVID. So it was already in the works. We just don't know what the impact will be during COVID and post-COVID. For employment-related matters, we've seen reports in the industry of whistleblower retaliation claims from warning about inadequate measures to protect personnel and patients from COVID. There's been wrongful termination. There's been violations of the FMLA or Families First Coronavirus Response Act about amounts paid or unpaid leave. From a directors and officers perspective, COVID-specific claim trends around alleged negligence for wrongful action or inaction, such as failures in contingency planning. And for cyber, I mean, I don't know if anybody can get up any day and not hear about another cyber attack. And remote working has added to that with the phishing scams and data compromise issues by cyber criminals. I mean, I always say if those cyber criminals would use that intelligence for something good, they could do amazing things, but that's not going to happen. I would ask all of you to make sure that you're talking to your insurance broker or your insurance company about what training or tools they might have to help you train your staff and to protect your systems. I can tell you at PI, our IT team often sends us phishing test emails to see if we'll bite. And they're not being mean by doing that. They just want to make sure that it's top of mind, that we don't click on the wrong thing and open our system to these cyber criminals. So we've talked about what happened in the marketplace with consolidation of practices, increased competition, driving down rates, and how claims costs are increasing. So what's next for all of us? To help illustrate this, let's go back to my favorite, the combined ratio. If you look at this graph, it was a study released at the end of 2019 where they reviewed 35 MPL companies. And from 2015 to 2019, the combined ratio deteriorated by 22%. It was significant. If you look between 2018 and 2019, it got worse by 12%. And I know 2020 is going to be similar. So that deterioration is directly linked to that red bar graph that you saw about the hard market in the NPL space. AM Best has given the NPL industry a negative outlook. And for those of you who might not know, the AM Best is an organization that monitors the financial stability of insurance companies. We had a negative outlook last year. We have a negative outlook this year. I think in 2019, we might have too. The negative outlook is because of depressed demand, diminishing reserve redundancies, and they're concerned that our losses are going up faster than our rate increases are going up. And last of all, there's the impact of the COVID-19 pandemic that we just don't know. We have not gone through this before. Okay, I apologize for this tiny print on this slide. I call this actuary print because it's so little. What I really want you to take away from this slide is everything to the left is in red, and it's for Washington and Oregon. We looked at the top carriers in those two states. Everything in red was a rate decrease. Everything to the right, you'll notice, is black. And those are all the rate increases, including PI, that were filed in 2019, 2020, and 2021. So you can see in the last few years, we are definitely going back into that hard market. And my guess is that those of you who deal with your insurance programs at your organization, it wasn't just your medical professional liability that went up. You probably saw it in your property rates, your fleet auto liability, your cyber. These things that we've been talking about today are impacting not just professional liability, but lots of other lines of business. So we've talked about a number of things today, including how the healthcare landscape has changed, the impact that it's had on the NPL carriers. Combined ratios, including PI, are going up. Claims costs are continuing to rise because of social inflation, the reptile theory, uncertainty of COVID-19, all of those things. And it's all information that you can share. It's Friday. I'm sure if you're having a glass of wine tonight, you can share it with your friends. It's great information. But seriously, we hope that what we went through today just gives you an idea of why your insurance rates might have been going up. I see that probably continuing in the near future. We need to take those rates in order to have that combined ratio, not at 110 or 119, which it was, so that we can be here to support you. The good news is you have organizations like WSHA that are out there doing wonderful work in healthcare's help. We have our own lobbyist who does great work. I know other carriers have lobbyists. There's other associations that are out there doing great work with the legislative system as well. And personally, many of you are involved. So that's all super helpful. The other thing is your carrier's defense attorneys are all looking at the same information and creating strategies to mitigate what's popping up over the last couple of years. So with that, I will see if we have any questions. Thank you for your time today. I don't know, I'm going to give you, on the screen, you'll see my contact information, as well as Maria and Nancy, who are online, and Alan Moorhead, who is our business development person. All right, well, thank you very much. Have a great rest of the conference, and I look forward to seeing you in person next year.
Thank you, Claudette, for that excellent presentation. That was a wonderful, well-rounded presentation to give us a snapshot of where we've been and where we're going and what the future might look like. And thank you very much for all that you do. And thank you and your team for participating today.
Thanks, Michelle.
All right, great. Okay.
The introduction's next, or is this Michael?
This is Michael. Michael's on.
Michael?
I am ready.
All right, hold on one second here, sir. There you go.
All right, I think we're ready to get going for the afternoon. Well, sort of the afternoon, not quite yet, but my name is Michael McDermott, and I'm a partner at Johnson Graffi Chemones and WIC, and I am the president of WHCRMS for the next year. I'll be introducing the remaining speakers for the day, and we have 2 more sessions, door prizes, and then some closing remarks. And the next speaker that I'd like to introduce is Rachael Smith. Rachael Smith is a veteran frontline certified critical care nurse in a COVID intensive care unit in Virginia Mason Franciscan Health, St. Francis Hospital in Federal Way, Washington. During her 17-year nursing career, Rachael spent several years as a hospital risk manager at St. Elizabeth Hospital and St. Joseph Medical Center, driving safety initiatives and developing process improvements with senior leadership teams. Rachael's risk management experience combined with bedside expertise creates a unique perspective that lends itself to promoting a safety culture focused on system improvement and successful change integration. As her career has evolved, Rachael maintains active roles in hospital shared governance as a passionate voice for recognizing compassion fatigue in the healthcare setting by advocating campaigns of awareness and ongoing prioritization of staff experience as a component of hospital safety and error prevention. Rachael has her bachelor's in science of nursing from Washington State University, as well as her master's of science in nursing and master's of healthcare administration from the University of Phoenix. She has been an active member of the American Association of Critical Care Nurses for 13 years and is the co-chair for the Virginia Mason Franciscan Health System Nursing Shared Governance Committee. She is the staff co-leader of the St. Francis Hospital Safety and Staffing Committees. In addition to her passion for nursing, she is a mother of the most curious and adventurous, nearly 5-year-old autistic son. Rachael is an acting preschool homeschool teacher and an ardent champion for social awareness of neurodiversity and autism. Please give your attention to Rachael Smith.
Hi, so thank you so much. I'm very honored to be included on this agenda today, and I'm very excited to share some of the work that I've been doing over the last several years related to compassion fatigue, burnout, moral injury now, and also process improvement work related to that. So this has been a journey that I plan to share with you just to allow you to jump on my my journey with me and kind of learn some of these pearls that I've adapted and integrated into some of the work that we're doing at the bedside now in the state of COVID. So please feel free if there's any questions or terms that I use that you're not terribly familiar with. I'm very open to just dialoguing and sharing because some of these concepts aren't called the same thing at every facility. And then there may be things that you just want to know more about. And so I do encourage you to ask questions along the way. I'll try to pace myself so I don't get too excited about things. And then again, give you some time if there are any questions. So I'm here to talk to you about compassion fatigue and moral injury. I also hope to tie into some concepts related to risk management and the work that you do every day in the hospital systems that you work in, respectively. My objectives for this particular meeting are to define compassion fatigue, if you've never heard that terminology before, also to introduce you to the concept of moral injury in healthcare, which is really pioneering in a lot of different literature and leadership groups as we start to look at cumulative damage that occurs with compassion fatigue with frontline staff. Additionally, I'm going to try to give you a little bit of a snapshot from the frontline perspective. What does it mean to be a worker or to execute these plans created for safety and process improvement on the front line and that change integration. And then finally, again, discuss some opportunities and ways in which that you can partner with this knowledge and apply it to your prospective hospitals at the biggest and most important tables that you get to sit at. And so we hope to just gain your support and understanding of these topics, and hope that you partner with us to be those advocates to talk about these things and bring them to the table when change and process improvement is rolled out. So I do have some disclosures and conflicts of interest. So you heard that I am a Virginia Mason Franciscan Health employee. We've had several brand changes, I'm sure you've seen over the last couple of years, but this is where we are right now today. I've been an employee of this system since 2004 when I was a brand new nurse, but over my 17 years, I've also done agency work and worked in about 9 different intensive care units along the I-5 corridor. So there's likely a chance that I may have even been in your intensive care unit along the years of my career. And then additionally, as a risk manager, I maintained a per diem position in intensive care because it is a strong passion of mine. And I feel like it also kind of helped me be a little bit more engaged as a risk manager, understanding the workflows as a bedside nurse. I've also been a hospital supervisor and currently just work weekends in the intensive care and also occasionally as house supervisor at St. Francis Hospital in Federal Way. Additionally, I wanted to include a little bit of my personality profile. Shortly after becoming a risk manager, I did the Strength Finders. I'm not sure if anyone's had the opportunity to do that, but Strength Finders helps you find your 5 dominant strengths and what you're really good at. And so in full disclosure, I'm a learner. I like and desire to learn and continuously improve. I'm an achiever. I have a great deal of stamina and I enjoy hard work. I love input. I like to collect information, collect data, get to understand things a little bit better. I'm naturally restorative. I like to fix problems. I'm adept at dealing with them and sort of mealing into the issues and really finding root causes. And I have a strong sense of responsibility in the sense that when I commit to something, I am committed to it and I will see it through to the end of the resolution. Now, under the Strength Finders, they have determined there's 4 sort of umbrella components to strengths. Mine all fall under strategic thinking and execution. I think strategically and I make things happen. The other 2 umbrellas of Strength Finder are relationship building and influencing. And so people who are strong in those areas are really good at convincing people of their stories or compelling them for change, and that is not my strength. So in full disclosure, as I present this information to you, know that that's not my strength. I'm much more effective in rooting problems out and coming up with solutions than I am implementing and influencing change. So this is my attempt to share some of those struggles and those ups and downs and how that has just kind of guided some of this work. And then again, you know, been challenging for me along the way. So if there's opportunities, things that you think that I could share that make this more effective, certainly feel free to share that because I am open about and accepting of the fact that that is not my biggest strength. So those are my disclosures. So why compassion fatigue and sort of, you know, where did this come from? So in 2016, I was blessed with the birth of my child and went back to bedside ICU nursing. And whilst I was there, I knew that it would be important for me to participate in our unit-based council or our shared governance. And that model, if you're not familiar with it, is a council that operates in a particular hospital unit. And that council is in charge of implementing change and process improvement, as well as other components of shared governance, which are that area I'm not so strong in, which is that team building and kind of that woo and kumbaya, not not my area of passion, but I participate for the how are we going to roll in all of these quality improvement and process improvement works. That's my interest, and that's what keeps me engaged in my work. And so that's why I sit on that council. And typically I'm mostly involved in that element. But in 2019, we were trying to identify a focus of our particular unit-based council in our critical care department. And whilst we had many other quality projects that we needed to work on, the feedback that we were getting from our frontline nurses was that there was this feeling that there were hard times that were happening, and they sort of occurred and then they were gone. And there was really no time to reflect or to share conflicts that people were experiencing, or they may go to the charge nurse and say, wow, that was really tough. And the charge nurse would be like, well, that's the work. So, work on trying to find ways to deal with that, essentially. And so we were really getting this sense or impression from our evolving critical care team that our newer nurses were really struggling with these challenging scenarios and weren't really getting the peer support from their leadership at the front line. So those charge nurses or their experienced veteran coaches that maybe helped them during their residencies. And so for 2019, our unit-based council said, wow, well, that's not really the unit we want to work in. And we certainly don't want people to feel that way when they're, in our unit. So what can we do to get a little bit better at that? And so that became our focus. And naturally, as that was identified, then my sort of processing and the way I operate really took over, which was, okay, let's do a needs assessment. Let's go to the front line. Let's see, where these really these gaps are and what do we need to insert to fix that problem. And so after really looking at the literature, looking at the climate, and looking at the mix of our unit, we decided that, maybe the lowest lying fruit or our easiest opportunity to support everyone was to implement a post-code debrief. Maybe we could do just a short huddle after a bad event and really just do a round robin and see, is there, is someone crying in the corner? Is someone struggling, to go to the patient and take care of their other patient now having just experienced this bad outcome? And would this be a doable ask? And so we started to create this document on the backside of some of the leapfrog requirements for our code blues and the other requirements for our code blues. We were trying to integrate this little round robin for the charge nurses to sort of check and see how everyone was doing when these bad events happened, or unexpected events, or events with the highest amount of stress and maybe loss for those newer nurses that they were experiencing. So we looked at the model from VA. We came up with a really good, what we felt was a simple check and barometer check so that we could elevate these bad outcomes and we could elevate them to the level of the manager so that they might be able to help with the chaplains to come around on those nurses or find some support for those people. And in all that literature that we were really looking at, this term compassion fatigue just started to populate in a lot of the more recent literature. And I'm thinking to myself, compassion fatigue, what does that mean even, right? And how does that have to do with, this shift that we're getting in our culture and this feedback that we're getting from newer nurses that they're not really feeling supported. So what is that? And so in the literature, they really sort of define compassion fatigue with these three elements. And so the first component is compassion satisfaction, that meaning of joy that you get as a nurse when you're caring for that patient in need. A lot of people become nurses because they want to help. There's obviously a section of them that love the financial stability and love the work and like the flexibility of the career and maybe don't have that emotional connection to work. But a lot of us find the value and the connection in the bonds that we form with our patients. So compassion satisfaction, are they getting that time to find satisfaction in the work that they're doing? The second element of compassion fatigue is that trauma and the stress. And so that's the feeling of despair that can elicit these physical and psychological symptoms in the nurse. So in our research or in our initial thoughts, what we thought that was a secondary trauma was really related to an unexpected loss. Were we expecting that patient to code, or perhaps a prolonged death experience that involved a lot of medically futile care? And how do you get compassion satisfaction when you feel like you're torturing somebody, or you feel like perhaps their medical living will isn't aligning with what we're doing to that patient? So is that causing, the secondary trauma and stress? And sort of those two dynamics sort of play off each other to develop that third component, that burnout, right? That's that cumulative stress or the repetitive instances where these things keep happening and you're not able to walk away from that feeling to another room to truly get that compassion satisfaction with the next patient. Are you truly able to feel that positivity if that negativity is looming overhead? And so a lot of these concepts, a lot of these struggles that the nurses were experiencing, as I'm trying to examine it from the 30,000 foot view, is this sort of balance between, are you finding satisfaction in your work? And then what is this stress and trauma doing to those individual nurses? And how do those two elements sort of work off of each other to develop a staff member that wants to continue to come back to work every day? Or when they do return to work, are able to get into the mindset of a supportive, pleasant person to work with, right? So I was struggling in implementing a lot of this post-code debrief work, and we're doing our check and adjusts in 2019, and we're really looking at, why aren't these post-code debriefs easily being managed? Are we effectively helping anybody with all of these works that we've been doing? How is this aligning? How effective are we being in our unit-based counsel? And then something tremendous happened. I don't know if it's tremendous in a good way or tremendous in a bad way, because I'm sure many of you can imagine all of the strategic priorities that all of the hospitals are trying to manage. This particular year in 2019, the system that I work for has an annual update requirement where every employee attends this annual update, and a lot of the messaging and a lot of the regulatory items are achieved at those meetings. And during the first 15 minutes of that meeting, for every employee for our system, they listened to our patient experience coach. And this patient experience coach spent 15 minutes talking to every employee about hiding their tattoos and making sure their hair looks nice, and being sure that when they show up that their scrubs aren't wrinkled, because patients don't really like wrinkles, and you don't want to look like a bum. You really need to look like just sharp and crisp. You need to look like that, and you need to listen to how your patient likes their water. And when you're doing handoff, make sure that you as the nurse, you're telling that next nurse, hey, they like their water, room temperature, no ice, and they like their, pillows to be changed every time that you go in there. And, their husband is flying in from a late flight tonight. So if you want to be that nurse that goes the extra mile, prepare a bed for that weary traveler at the bedside so that staff, so that patient in the bed will be like, I am the most important thing in this hospital right now. Now, while I don't disagree with the messaging, and I don't disagree that those interventions would probably give us really great satisfaction scores, what I was wrestling with was this disparity of work and this disparity of things, right? All of the things that we ask the staff to do. And when I say things, I use that not as a derogatory term to the work that nurses do, but in a shift, there are hundreds of things that we need to do for every patient, for every heart failure patient, for every high fall risk patient, for every skin risk patient, for every central line, for every Foley catheter, for every surgical site infection, for mobility, for length of stay, for all of these indicators that we get messaged about, every smart pump that's programmed or not programmed, every medication error, slip, or lapse that has happened, all of these competing priorities and the mindfulness of the nurse just for foundational Maslow's hierarchy of needs safety, just foundational stuff, the stuff we see, right? When we do RCAs, when we do bad outcome investigations, all of this foundational safety issues that that's if you have perfect staffing and you don't have sick calls and you don't have a pandemic behind you, just the volume of things that bedside nurses have to do for every specific patient. And here this guy is in the fanciest of suits, you guys. He had a very fancy suit on with lots of patterns and a really shiny tie. And he was telling us this room full of people, and I can't really gauge the rage that was bubbling inside of me, but I was so mad at him in his fancy outfit in front of this room of people that work like horses sometimes. And he's like, make sure your pants aren't wrinkled. And I was thinking to myself a lot of things. I guess I'll just presentation this for you, that it was a big disparity. And I had a lot of feelings associated with this. So that bomb that you're seeing was kind of this eruption inside of me where I thought to myself, this isn't going to go well, because I'm just, I participate at the system level. This person has come and spoke to our system level, and I have some things that I feel like I need to share with this person, because there's a huge disconnect from this ask. What he was saying was just this, simple ask to just add those little elements into the work, the list of things that we all know we need to do for these patients. And I felt like he was so off base that I needed to fix that. And that was something that I then put on myself I committed to that, to share that information to him. So we had our crucial confrontation. I crafted an email because I didn't trust a lot of my emotions, that I really needed to get some of these thoughts out in a cohesive professional way. And I crafted that email to him, and I included an annotated bibliography of all the literature review I had done on compassion fatigue, all of the recent up-to-date peer review literature on this topic, and how, if he wants these 5s that he really needs to look at the alignment of the asks of frontline staff and the assessment of the current climate of patient care. And really, if he wants those fives, that's where his work should be, not in asking to make sure that we've dried our pants all the way and that they're not wrinkly. So my ask was that we look at creating space to let these nurses reconnect with why they became a nurse. Create those spaces for those nurses to cry if they need to after something bad happens, and be supported by their peers, and give them moments to feel those feelings before they go into the next room with a smile on their face, pretending they didn't just see what they saw in the next room before them. So I attempted to make this presentation. And so that presentation I had shared with Anne, who participates in this association. And this is part of the reason why I'm here today, was this bomb and this presentation and my advocacy for recognizing compassion fatigue, recognizing the need for an alignment of the workload to the work function that the nurses perform. So what is compassion fatigue, right? What is it? And so on your screen, you can see probably a lot of things that you relate to, because quite frankly, you all see pretty awful things too, and participate in some of the most challenging conversations I've ever had, or as a risk manager, and trying to discuss with people when things don't happen the way we intended them to happen. How do we support these folks, and how do we help these staff members get a healing moment from these events? And so, you know, when we do root cause analysis, I know we sometimes just briefly talk about climate, culture, partnering, how is the atmosphere of the unit that night? And for people that constantly operate in a state of chaos and disarray, these things are, you know, common practice. This is what they expect almost. You know, frequent call-ins, regular slips and lapses, grouchy, angry nurses, cynical thoughts. Oh, get over it. There's gonna be a lot more dying along the way. So you got to learn how to, you know, compartmentalize that and move on, you know.
Rachel?
Yeah, so the compassion fatigue symptoms. So symptoms of that are absenteeism, errors, anger, cynical thoughts, increased complaining. I know you've never heard that. Lack of joy or empathy toward patients, slowness of thought, difficulty prioritizing tasks, difficulty initiating routines, inability or anxiety. Let me minimize my picture of myself. Inability or and or anxiety, preoccupation with minor issues and familiar tasks. And sometimes we call that, I see in process improvement, you know, those sacred cows of nursing, when we talk about changing handoff or how we round, the preoccupation with those familiar tasks, indecision and lack of concentration, loss of initiative with fatigue, exhaustion and poor self-care, those wrinkled pants, physical symptoms such as headaches, substance abuse, inability to relax, and physical symptoms such as symptoms when they're at work. Sometimes people can experience nausea, heart palpitations, or other anxiety issues. We've had a nurse before who called from the parking lot because they couldn't get out of their car and come to work. So true symptoms, physical symptoms that people manifest that most frequently are met with, I think you need a vacation, or I think you need some time off, or what do you need to do to fix that, right? You need to monitor that because I don't think it's going well for you. That's a lot of the feedback people get when, we start seeing these trends. And sometimes with nursing, the older we get, the more we sort of excuse it, right? They're just old and jaded. They're just cynical. They're just burned out, that those things are to be expected. And that's the expectation of that environment that we're working in, right? So how does that manifest, or how does that then become something that escalates beyond just a collection of symptoms to an actual instance of injury? And I know that's a big concept or a big next step, but this is constantly like in my mind every day that I work. When we talk about moral injury and the origins of this term of moral injury. So Talbot and Dean, they describe moral injury as let me see, I might have actually skipped over one. I got a little bit disconnected there. No, I think we're good. So, oh, thank you, Anne. Can you guys see Anne's presentation or my?
Yep.
Yes.
See your slide. We see a
Yay!
slide.
Yeah, so we're on, let's see, the next, oh yeah, so you guys can take a peek at that. So maybe the next slide. Thank you. So moral injury. So kind of talked about compassion fatigue, talked about what those symptoms look like, but where do you get moral injury, right? So moral injury is actually a thought that has been brought to the table by these physician leaders, creating this discussion of a discrepancy that occurs in healthcare workers. And moral injury originally came as a term brought forward by Vietnam veterans. In Vietnam, when those veterans came back, they were experiencing a different PTSD, something different than what was known as common experiences with war. And this concept of moral injury came about because the soldiers were asked at times to blow up or to attack areas where they were not 100% sure that who they were attacking were the actual enemy. So their personal morals that you would never hurt an innocent person were then being compromised because the ask was then, we're not 100% sure that all of these people are the enemy, but we know that there are some enemy in there. So we're going to need you to drop this bomb. So these war veterans were coming back thinking to themselves, what did I do? Did I kill innocent people? Was it worth it? Did I just compromise my own individual beliefs to then was for some greater good, this struggle that they were having? Well, Talbot and Dean are really arguing from the physician perspective that this moral injury is alive and very well in healthcare. And what happens in healthcare is that you get into it thinking you're coming to help people, right? You're coming to change the way that healthcare is provided. You're going to save people. You're going to help them. You're going to bring about a change, and you're going to be something really important to these patients. And the reality when you actually come to work is that the healthcare climate is bombarded with tasks, so many tasks that you're not really creating that space for them to get that connection, to feel that reward at the end of the day. Because if we've got 200 tasks for 4 patients and you're one person and you've got to take your 1 hour and 45 minutes of breaks that the law now requires for nurses, and there's really nobody in, not all hospitals have break relief nurses. No one's jumping in to make sure your work's getting done if you're actually taking your breaks. So how do you do all of the things? And as we continue to add more things to do, are the nurses that came into this work to heal and help and improve, are they having to skip things that they know their patients need in order to just fulfill those basic Maslow's hierarchy of needs? Did they have to skip turns on a patient that's at high risk for skin breakdown because their fall patient was more demanding, or their mental health patient needed more time and attention, and there was really no one in to step to make sure that all those other tasks were getting done? So are we creating a work list that's here with time and availability that's only here, so that these nurses are coming to work every day with a list that they're failing to meet every day? So you're just coming to work and you're not able to do what you want to do. And if you're really truly coming at it from a place of compassion and care planning, are you able to do the care plan that you want to implement for that patient? Get so-and-so out of bed for the first time and do some early mobility. Walk someone in the hallway that really needs to build their endurance. Do you have the time? And is there enough staff to do the things in order to find fulfillment and reward in your job? So they're really bringing forward this concept of moral injury in healthcare, because the way the system is aligning, the discrepancy is becoming so profound that, like a physician, if this person's insurance doesn't qualify them for this expensive chemo regimen, they're having to tell the patient, I'm sorry, you either can pay for this or you can have palliative care. Your only option is something that isn't within my ability to provide to you, right? And so there's this discrepancy because healthcare workers got into the work to help, but now they're realizing the work itself, may not be very realistic. Or are we heading to a place where it's just frankly impossible to get all the things done? Next slide, Miss Ann. Sorry. So all the things and all the words, I think about this as we always go over our strategic priorities. When I think about all the competing elements and all the mindfulness guidelines that we are blasting at the huddle every day before we go onto the units, the focus of the week, what we're thinking about, when we have six sick calls or 9 sick calls, which we regularly had in COVID, because frankly, all these, moms and dads have children at home who are struggling with remote learning, have families at home. They can't drop their children off at grandma and grandpa's because they work in a hospital full of COVID, and it's not worth risking their family's health. We've had so much variation in our staffing because of all of the ripples of COVID. And even before that, just high turnover and, changes in healthcare result in people starting to dislike the job. And you have a lot of different mixes and different ratios of changes as things like productivity are limited. And Talbot and Dean go in a lot about how we've diverted a huge amount of funds for staffing and patient ratios for things like electronic health record. I mean, I can ask all of you, how's that working? Do we have a better record of the care that we provided? Is it improving our patient outcomes? Do we have a more accurate legal record for us to discuss how much care we're providing? Or are we just really talking a lot about it in theory, except for those tasky work lists items that we're asking people to check these boxes? Does it actually illustrate or describe the care that we're providing? Are all of these costly improvements really affecting the outcome, improving reimbursement, creating effective lists for us to work off of to make our jobs easier? Challenge all of us, and I rarely feel, even after years of having those electronic records, that we're there yet. But it's cost systems millions of dollars that they've had to divert from getting better bed alarms, getting better pumps, getting better facilities, getting more beds. And then again, those experience mixes. And then what's the culture of your unit, right? How are new nurses received, and how are your veteran nurses feeling? Have you checked in on those crusty old goats? Because they do have a lot of influence over if newer nurses are going to stay. And I mean crusty old goat with the most compassion possible, because I am definitely that goat from time to time. Go ahead and next slide, Miss Ann. And I just thought this was one of the most powerful moments as we look at this and we think about it, that moral injury describes the challenges of simultaneously knowing what the patient needs, but being unable to provide it due to constraints beyond your control. So we know what they need. You know, when you hear about a wrong side procedure and you're thinking, why didn't they just stop and ask? You know, why didn't they just do the timeout? Why didn't they just do it? Did they not know it needed to be done? You know, what else did they know needed to be done? They know they needed the site prep to be done. They know that physician needs the number 7 dingle whopper for the procedure. They knew all the other things, but they forgot to do the timeout. And the physician was thinking of all the other things they were doing and they forgot. So when we talk about that moral injury, it really is that disparity between what you know needs to happen, right? It's not that we don't always know. It's just, were we mindful enough about it, right? Go ahead, Miss Ann, to the next slide. And so then, the question, how are those errors managed? I've worked, like I said, at several different facilities, and they all sort of are managed differently. Sometimes your name goes up on the board of shame. Sometimes we transparently talk about them in positive ways, and other times, you can't help but feel like you were the one that failed. You scanned the wrong code on that label. Everybody else knew which label should have been scanned. You were the one that lapsed, right? You should have known that. Or maybe you didn't read that policy to completion or something like that. So how do those staff members interpret bad outcome investigations? And you can't always control that, right? You can't control, even if you coach people through that and say, that's not your fault. The system should have been better and it should have helped support you. But how do you as the individual still feel, especially if only 2 people got interviewed and you were one of them? It doesn't feel like it's a big system issue. It kind of feels like it's a you issue, right? So anytime I talk to people after they've participated in an RCA, now that I'm not doing risk management, I kind of talk to them a little bit more about that and just let them have the space to feel those feelings, and just, again, try to reassure that, that's not necessarily the way in which we want things to go. But these are the opportunities that I feel like risk has in outlining all of those tasks and validating the impossible amount of work that some people in some areas have to face in order to provide safe care. Next slide, please, Miss Ann. So I put this on the slide, not because I think we intentionally use guilt and shame to shape behavior, but more so that it's becoming more commonplace to say things like incidents of harm. And I sat at the table when people said, oh yeah, we need to call them incidents of harm, because, if the nurses know that a catheter-associated urinary tract infection causes harm, causes death, can cause extended length of stay, can cause additional medications, which can cause different reactions and C. diff. If they know these things, well, then surely they will do better jobs at, getting those Foleys discontinued early, or being sure to use this appropriate peri-pack that we've provided them. We use these terminologies to almost, push people that this is what will make it more mindful for you. But in the end, does this then become yet another thing that we're asking them to do, or putting this pressure on them psychologically to conform to these asks that we're presenting them, and only compiling really that stress and that pressure that they're working under, that if I don't do this, they're going to die. If I don't do that, they're going to die. If I don't give this antibiotic on time, they're going to die. And this is a constant state of mental intensity and exhaustion that it becomes an environment people don't necessarily enjoy enduring for very long. Next slide, Miss Ann. And then COVID came. This picture was a memory book that we did for our intensive care unit at St. Francis. We were not very lucky, and everybody experienced in Washington the pandemic very differently. But for over about 15 months, our intensive care unit was at least half, if not more, long stay COVID patients that were really challenging to take care of. And, you know, all of this work that we had been focused on prior to COVID sort of went out the window. A lot of the quality initiatives, a lot of the best practices, a lot of those higher levels of Maslow's hierarchy went out the window, and they weren't even a consideration. Half of the time it was just sheer survival of our staff, survival of our patients, mental health, and just this strong team development. We're all kind of in this state of healing because a lot of really bad things happened in our unit, and a lot of bad things happened all over the nation. I talk about this, that we know of 3,600 healthcare workers that died early in the pandemic. And these were the things that our team was watching, right? And we still had to come back and reuse our masks. We got a lot of flack in the very beginning for wanting to wear masks before they were required to be worn on the unit at all times. They didn't want us wasting the PPE, but it was hard to be in the same room when you didn't know, in the same unit, in the same area, when you didn't know what other people were doing. And if they were maybe sick, because we didn't have testing capacity, we didn't have effective treatments. We watched the spouse of one of our co-workers die very early, and he worked as a frontline healthcare worker outside of the hospital. And, we still don't have any official counts of the healthcare workers that perished. And there was a lot of lost trust during those times, trust with supply chain and trust with leadership that we were safe. We were building anterooms out of plastic wrap and magnets and zippers, and we were having to refocus every time, very intentionally, every time we were going in and out of rooms, to make sure our pumps didn't run out of medicine the minute we walked out. And there was endurance of stress that you really can't even measure. And we thought it was bad before, but really, truly, this put a highlight on how fragile the system truly is. And I don't know how many nurses we lost, but I think even more frightening was how many new nurses we had to train in this environment. And in critical care, half of what you really need is elbow support when your patient's not doing well. Someone in there kind of explaining, oh, let's look at this, let's look at that, let's try to fix this. And there was no elbow support. Nobody was excited to go into those rooms. And frankly, we didn't have enough supplies for multiple patients to go in the rooms. We really had to get creative with ways in which we provided care, where we could provide second eyes on situations that didn't seem to be going well. We did create a sort of, I don't know what's it called, a memory book from this event full of pictures. We tried to collect positive pictures along the way. We tried to take pictures of our resilience building to remind ourselves how we got through it. And we created some plaques on our unit with all the nurses that were able to stay and work through the pandemic. And we're really trying to heal from a lot of that, because a lot of people just died in very morbid, horrible ways. And we dealt with a lot of violent aggression over the phone from families because of the mixed messaging about COVID from our president at the time. And that was really hard. That was hard after beating your butt for days and days to just get chewed out and be called a liar and, be threatened. And those feelings are still very strong there. And there's still a lot of healing that will need to come from that. But not every unit experienced that. A lot of people had low census, and a lot of people, didn't have to endure all of that. And so, I encourage you all to look at those environments that had to flex. Look at how those units supported one another, and then consider those when you have to go through any reviews in the next year or two, because it's going to take some time, quite frankly. Go ahead, next slide. Oh, these are just some pleasant things that I thought I would show you. This little meme on the far right came out several weeks after COVID was really real, and we were reusing our masks, and this meme of the parachute on fire and all of us plummeting to the ground felt very legitimate, and we all just kind of held hands and plowed through it. And then the middle picture, my mom quilts. She used mountains of her fabric, and she quilted masks for all of us because they didn't want us to use the hospital provided masks for the first couple months, so that we would have masks to wear just sitting in the unit. And the cappers that we wore, we didn't have enough of the foam pieces, so it was just like bare Velcro on our foreheads, ripping at our heads. And so she created these little head wraps, and that was the one she made for me. So I felt very, very fancy while we were in our unit, just trying to not get each other sick and not get our patients sick. So next slide. So my ask, or my hope, that when you guys move forward from here and you take any of these thoughts away, is that you hope to reframe some of these discussions, help to call out unintended discussions where we look at using compelling why stories in a way that could be interpreted as shame or pressure. Ask nurses, ask nurse managers, what does their staff support plan look like? Do they have regular employee satisfaction work? Do they make this a priority as part of their daily work with their particular units? And use considerations like moral injury when you advocate for patient safety, when you talk about staffing ratios or cutting staffing ratios, how we're looking at staff retention and success truly at process improvement and quality and safety improvement work. And partner with your units when you create improvement plans. It may seem like, turn clocks or audits or things like that are helpful, but make sure those don't get delegated to the nurses to do, because there's, quite frankly, entirely too much work already that needs to get done that is already overwhelming. Yeah, we'd rather give a nurse a break rather than audit their chart and give them 3 more things to do. The more that you can find system opportunities to improve safety and times in which we can leverage our technology or leverage our equipment or leverage our resources in better ways, advocate for that as much as you possibly can. Oftentimes that lack of documentation isn't the lack of training or lack of enforcement. It's usually a symptom of a bigger problem. And if there is any way that you can help and advocate for that, you'd be saving your staff retention and the culture of that unit. So it is very value added and a great opportunity. Next slide. And then, the resilience stuff, right? The resilience stuff, you don't go to someone who's burned out, fried out, ready to, throw their kids' laptops through the window, ready to, quit their job and run out of the place and tell them, you know what, you look like you need to schedule yourself a massage and sniff this lavender oil and get go listen to some guitar music. That isn't the way that we support or build resilience. Those are great ways that individuals can build resilience, but everybody does it in their own way. And, be mindful of that toxic positivity where people want to vent and there's really not a safe place for them to do it. Just pull up your bootstraps. Well, you're never going to get it done if you don't, check your attitude at the door, those types of things. Really, find ways to bring your team together so that teamwork comes naturally. That's really helped in our unit is connecting people together. We've been doing a lot of resilience of what does resilience mean to me boards? What is a thank you to me? If I do something great for you, my favorite coffee is this, you can always go get me a coffee, from the coffee stand downstairs. So it doesn't always have to be a kudos note. It could be something different. And so are your units finding ways to recognize one another? Because sometimes bringing the team to lift each other up is a lot easier than trying to come up with very exciting events that burned out, tired, exhausted people aren't going to attend. And that was something we found out during COVID was we couldn't physically meet. And then when we did meet, it was hard to really get people to participate because a lot of people are really tired right now. So getting creative with strategies, we did virtual sip-in paints. We've done virtual happy hours. We've done virtual coffee talks. We've done a lot of things via Zoom where we just create space for people to feel validated and to share their concerns and how they feel like the workload's impacted safety and try to create those stories that are much more compelling than just theoretical discussion, which is kind of what I'm doing now, but hopefully also sharing some broader concepts. And then next slide. All right, so that's me getting my second shot. I know you can't really tell when someone's smiling through a mask, but I'm smiling and I'm super excited. Definitely toward the end of the pandemic, I spent any extra time I had not working in the COVID ICU. I worked in our vaccine clinic because I needed it. I needed to be around happy people that were getting their freedom back and that were excited and full of joy and gratitude. And that was very healing for me, quite frankly. And so I don't know. I think I got 1 or 2 minutes if there's any questions. Or I'm 1 minute over. Well, thank you guys again so much for having me. I am very happy to share this work and I hope that it adds value to you.
Rachel, thank you so much for that. Your presentation really provided us with a lot to think about and things to consider in our own organization. So I really appreciate your presentation and your time today. Thank you.
Thank you.
I'll go ahead and I think we're ready for our next presentation. Our next presentation is the annual case law update. And this year our presenters are Levi, Larson, and Scott Beimer. Levi Larson, after a active duty tour as a Marine Corps judge advocate, Levi returned to the Pacific Northwest and joined Floyd, Pfluger, and Ringer, where he practiced close to a decade with a talented team of medical malpractice attorneys before starting his own firm recently, Larson Health Advocates. Levi's practice areas include medical professional liability defense and licensing and disciplinary defense. Levi attended the University of Washington for undergraduate and law school and was recognized with induction into the Order of Barristers. Levi serves on the Washington State Bar Association Board of Governors Judicial Recommendation Committee and is a member and former trustee of the Washington Healthcare Risk Management Society. Scott Beimer received his Bachelor of Science in Political Science from Texas A&M University in 2003. He received his JD from Seattle University School of Law in 2007 and his Master's of Law from Georgetown University Law Center in 2015. From 2007 to 2017, Scott served on active duty in the U.S. Marine Corps as a judge advocate. He deployed twice and has significant experience litigating cases in military court-martials. After returning to Seattle area in 2017, Scott has focused his practice on civil litigation and primarily medical malpractice defense. So if you gentlemen are ready, go ahead and take over your presentation. Thank you.
Hey, thank you, Michael, and good afternoon, everyone. It's a real honor to be here this afternoon. I, of course, would much rather be at the Washington Athletic Club with all of you, but nonetheless, we're here together, and I'm honored to be finishing a very informative lineup today. I've very much enjoyed learning about the inside baseball going on down in Olympia. Why our insurance rates are so high. Thank you for that explanation. And then I know now when I see my little sister, who is an emergency room nurse, and she's finishing a shift, and I'm in my fancy suit, not to comment on her wrinkled scrubs. I'm very, very honored to be presenting with my colleague, Scott Beimer, who I've known for over 15 years. I first met Scott on a very special night where the guest of honor was Charles E. Smith. And for those of you who don't know Charles E. Smith, he was Washington State's first African-American Washington State Supreme Court Justice. And he was also a Marine Corps judge advocate. I met Scott over 15 years ago, and so it was a real treat today for us to hear from our first keynote speaker this morning, Justice Whitener. I want to try to work in our theme of resilience in unprecedented times, and I know that the month of June is a month where we're celebrating dads and grads, and for all of you who have a graduate this year, my hat's off to you and your graduate, especially those seniors who have gone through a tough year of Zoom instruction that took a lot of resilience. For those dads out there, it takes resilience to be a father, but we're close enough to Mother's Day where I can say mothers probably are more resilient, and it's a special time at our firm. We're saying goodbye to Anna Mitchell temporarily. She's going to be out on maternity leave next week. So her husband, Jake, will be celebrating his first Father's Day this year, and he'll need resilience through those late nights and many diaper changes to get to the second one. Finally, I want to just come back to a nod to all of you and this presentation Rachael just did on moral fatigue. And I think we can all agree that we have had maybe experienced Zoom fatigue over the last year. I certainly have in some of these Zoom depositions. I know we started again the morning out with a bang with a Supreme Court justice, and my goal for the next hour is that we don't end with a yawn. So in that effort, I've planted a few Easter eggs for you. When Scott and I were back at Naval Justice School practicing our openings, we did a competition where we would try to work in military movie quotes. So I have a few of those throughout today's presentation. Keep an eye out for those. This is the time of the day. If we were actually all together at the Washington Athletic Club, I'd be looking, kind of exchanging glances with my friends from Johnson Graphy, some unnamed claims managers, risk managers. We'd kind of be sneaking out of the main conference room to assemble at Haggerty's to kind of do the after action report in the sports bar. I'm really sorry we won't be able to get to do that this year, and I look forward to doing that next year. I owed my friends at Johnson Graphy a couple pitchers of beer. Okay, with that, I'm going to pull up and share our presentation today. Oops. Okay, so our agenda today is we're going to be covering 4 cases. The 4 cases are Nordwall versus Height. That is a case involving statute of limitations. We're then going to move into Collins versus Juergens Chiropractic. That involves informed consent. We're then going to cover Abdul Wahid versus Eastern State Hospital, which involves expert testimony. And we're going to finish with Hermanson versus Multicare, which addresses attorney-client privilege against the balance of physician-patient privilege. And with that, I'll turn it over to Scott, who's going to discuss Nordwall.
Well, thanks, Levi. It's great to be here and great to be with all of you today virtually. I just want to add, if you are able to catch all of the military movie quote references, kudos, and you should email Levi to get a little gift from us. So our first case is a very recent 2021 decision from Division 1, the Nordwall versus Height case, which is regarding the statute of limitations for medical malpractice claims. So in this case, the plaintiff appealed a trial court's grant of summary judgment for the defense dismissing his medical malpractice claim due to a failure to file within the applicable statute of limitations. So here are the relevant facts. On February 24th, 2016, a podiatrist named Dr. Eric Height performed a bunionectomy surgery on Mr. Brian Nordwall's foot at Virginia Mason Medical Center. On March 3rd, 2016, Dr. Height conducted a post-operation follow-up with Mr. Nordwall, and at that time, he assessed that Mr. Nordwall's foot was healing well and without any complications. On March 22nd, 2016, the two had another appointment, and Dr. Height again assessed that everything was fine. On April 5th, 2016, Dr. Height ordered some x-rays of Mr. Nordwall's foot, and after reviewing the x-rays, reported that everything was still fine and without complication. On July 7th, 2016, Mr. Nordwall, feeling that something was not quite right with his recovery, decided to get a second opinion and went to another doctor, another podiatrist named Dr. Michael Brage. Dr. Brage ordered another set of x-rays of Mr. Nordwall's foot, and on July 28th, Dr. Brage showed Mr. Nordwall the x-rays of his foot and gave him the opinion that the pins in Mr. Nordwall's second toe had been improperly affixed during the surgery. Fast forward almost 3 years later to July 26, 2019, and Mr. Nordwall brought his suit for medical malpractice against Dr. Height and Virginia Mason. The defendants sought summary judgment, arguing that the applicable statute of limitations had run on the claim, and the trial court granted that motion. So the plaintiff appellant argument was that the trial court erred in granting the defendant's motion for summary judgment. Specifically, he argued that the 3-year statute of limitations on his suit did not begin to run until July 28th, 2016. And the court makes pretty short work of this one. The court reminds us that a medical malpractice suit must be brought either within 3 years of the act or omission that caused the plaintiff's injury, or within 1 year of the time the plaintiff discovered or reasonably should have discovered their injury was caused by an act or omission, whichever is later. A plaintiff may also allege that their injury is the result of continuing negligent course of treatment, in which case they must bring their suit within 3 years of the last negligent act committed by the defendant. So here, Mr. Nordval failed to heed the need for speed, if you will, on all three of these deadlines. He needed to file before February the 24th, 2019, which would have been 3 years from the date of the injury, or 3 years, or on or before February 5th, 2019, which would have been 3 years from the date of the last potential negligent act by Dr. Hite, or before July 28th, 2017, which would have been 1 year from the discovery that an injury was allegedly caused by Dr. Hite. Obviously, the latest of these three is April 5th, 2019, and Nordval didn't file a suit until July 26, 2019. Therefore, the trial court's decision granting summary judgment was upheld. Now let's turn and burn to our next case. Turn it over to Levi.
Thank you, Scott. And I just want to do a little bit of a side here. As was mentioned in the introduction, Scott went to Texas A&M. He really is a Southern gentleman, and we can blame Scott and the folks at Texas A&M for the Seattle Seahawks no longer being able to use the term the 12th man. The 12th man actually dates back to the 1920s when a basketball player in the Aggies stand was actually asked to come down on the field. Texas A&M trademarked the 12th man, and then during the Seattle Seahawks Super Bowl run in 2005, they proceeded to issue an injunction from the Seahawks using that term. And so we can thank all of the Aggies there for why people hate attorneys. Okay, now turning to the next case of Collins versus Juergens Chiropractic. This is a Division II case, and want to give a shout out to our friends at Favros, Aaron Cannon, and Mark Meltner. They did a really nice job with this case. So an overview of the facts. This was a chiropractic manipulation that resulted in a vertebral artery dissection and a stroke. The plaintiff had filed a complaint alleging negligent failure to conduct a proper workup, and they had also pursued a failure to obtain informed consent. The defendants filed a motion for summary judgment, and the trial court dismissed both of those claims. On appeal, Division II looked a little closer at the facts, and so let's unpack those a little more. The case involved the patient actually starting with a first chiropractor who then sold his practice to a second chiropractor. The patient had seen the first chiropractor 194 times, including several neck manipulations. The courts looked at the original consent form that was signed by the patient with the first chiropractor. As we all know, under the law of informed consent, there's no duty to inform a patient of facts they already know. So let's take a look at the original consent form. Nothing in the original consent form mentioned the risk of a vascular injury. In fact, it kind of downplayed the risks of the chiropractic treatment. You could almost say that the first chiropractor felt that the patient could not handle the truth. A little bit more of the facts here. The second chiropractor who purchased the practice from the first chiropractor performed a cervical manipulation. The patient heard during and after the manipulation, heard a sound, some crunching. They felt pain. After the manipulation, they went to their primary care provider who diagnosed a stroke. There was a neurology workup that actually tied it back to the manipulation. It said it was the cause. The cause of the vertebral artery dissection was the manipulation. It was confirmed on an MRI. The patient filed suit claiming, again, both medical negligence and lack of informed consent, and the trial court dismissed both of those. The appellate court took a look at the medical negligence claims and affirmed the dismissal of the medical negligence claims for failure to prove proximate cause with expert testimony. And the plaintiff in this case produced an expert who did testify that there was negligence in the workup, But of note, they said that the manipulation itself was within the standard of care. It was not the manipulation that was negligent. It was the failure to get a proper history and do a physical exam. However, the plaintiff's expert could not tie that failure to do a proper workup to the injury itself. And at the deposition, again, I don't know if it was Aaron or Mark, the Division 2 published opinion doesn't say, but the defense attorneys did a nice job of pointing out that hole in the plaintiff's case, that they could not tie the failure to properly do the workup with the actual injury of the vertebral artery dissection. And so when the expert was asked at his deposition, can you say that the failure to do the proper workup was the cause of the injury? He said, I don't know. And so the appellate court upheld this. And I think the practice pointer for all the defense attorneys is to be aggressive in pointing out those kind of negligence in the error claims, where you maybe have a plaintiff attorney saying, hey, your rear tail light is out, that's negligent. They're saying, well, it may be, but it doesn't matter when we're talking about a head-on collision. Turning now to the informed consent claim, the key issue there is the two-step test for materiality. The first step to consider is the probability of the harm and the nature of the harm and the probability of the risk. And the case law says that you need an expert to testify to what the probability of that risk is. Some of the past cases suggest there needs to be a percentage assigned to that, and Division 2 said no, you don't need to have an expert who gives a defined percentage. In this case, the expert they had said there was a greater risk because of the failure to do a proper workup, and there was a greater risk because of the force of the manipulation, and that those two things were material as to the probability of the risk, and that given in the light most favorable to the non-moving party, they held that that was a material risk that should have been disclosed to the patient. The second part of, or a second element of pursuing an informed consent claim is not only was there a material risk that needed to be disclosed, the second part of that analysis then is, well, would a reasonable patient, knowing that material risk, have still consented to the procedure? In this case, the appellate court said that's an issue for the trier of fact, and so they remanded on the informed consent issue. We'll now turn it back over to Scott for the case of Abdul Wahid versus Eastern State Hospital.
All right, and I would just want to add to the fact that the lawsuit between Texas A&M and the Seahawks actually occurred my first year here in Seattle. So needless to say, that first year was a bit awkward with me walking up and down Capitol Hill wearing all my Texas A&M gear. I got quite a few comments, none of them positive. So our last case is Division 3 case from earlier this year, Abdul Wahid versus Eastern State Hospital. Now, somebody once wrote that hell is the impossibility of reason. And that's what this place, Eastern State Hospital, must have felt like for Mr. Abdul Wahid. You see, Mr. Abdul Wahid was a patient along with another patient there, Philip Price, at Eastern State Hospital. And one day, Mr. Abdul Wahid saw Philip Price fall and offered to help him up. And for no reason at all, Mr. Price responded by punching Mr. Abdul Wahid in the chest. Abdul Wahid reported the incident and requested that he be moved to a different floor. Later the same day, while talking on the phone, Price again violently and seemingly without reason attacked Mr. Abdul Wahid, causing a serious injury. Just under 3 years later, the plaintiff sued Price and Eastern State Hospital and received a default judgment against Mr. Price. Now, the suit against the hospital claimed that there was a duty to exercise ordinary care to protect him and provide for his safety. Eastern State knew or should have known that Mr. Price presented an unreasonable risk of harm, and Eastern State failed to exercise exercise reasonable care to adequately supervise and monitor Mr. Price, or otherwise take reasonable measures to protect the plaintiff from harm. Eastern State submitted discovery requests, and after several months without answer, and this is a picture of Eastern State Hospital, which looks like it could come from somebody's nightmares. Almost 3 years, I'll back up. Eastern State submitted a discovery request after several months without answer, and there was a CR26I conference with no answer. Almost 3 years later, Eastern State filed a motion for summary judgment seeking dismissal due to lack of an expert. In response, the plaintiff said that they had an expert and that he provided her curriculum vitae, but did not provide, notably, a declaration from the expert. After resetting the hearing date twice in order to allow plaintiff to submit the declaration from their expert, the plaintiff requested a third delay. The affidavit from the plaintiff attorney explained that just weeks earlier they had given discovery requests to Eastern State Hospital, which were not yet responded to and needed for their experts' opinions. The trial court proceeded with the hearing and granted Eastern State's motion for summary judgment. Now here, the plaintiff clearly failed to provide testimony from an expert consultant, but plaintiff argued that expert testimony was not required for two reasons. One, the facts that he argued established negligence were so observable and describable without medical training, and the second being under a theory of res ipsa loquitur. The court reminds us that in general, expert testimony is required when an essential element in the case is best established by an opinion which is beyond the expertise of a layperson. Medical facts in particular must be proven by expert testimony unless they're observable by a layperson's senses and describable without medical training. Thus, an expert testimony will generally be necessary to establish the standard of care and most aspects of causation. Here, the plaintiff argued the hospital owed him a duty of protection because there was this special relationship between a mental health care provider and a potential victim of a patient whom the provider knows to have propensities to harm others. The hospital acknowledged that it did have a duty to protect patients against reasonably foreseeable risks of harm, including dangerous patients. But it argued that Mr. Abdul-Wahid did not present facts that lay jurors could determine constituted negligence without expert testimony about expert testimony about a reasonable inpatient psychiatric hospital would or would not have done in that situation. The court wrote that Mr. Abdul-Wahid conflated the existence of a mental health care provider's special relationship with medical negligence that can be proved without expert testimony. The two are very different things, the court says. The significance of a special relationship is that it gives rise to a duty to prevent a third party from causing harm to another person that does not otherwise exist. However, a claim stemming from a mental health care provider's breach of this duty is a medical negligence claim. The court stated that establishing that the defendant breached the duty might be provable without expert testimony, but oftentimes it will not be. Since Mr. Abdul-Wahid did not present evidence of the court says, a gross deviation from ordinary care that a layperson could easily recognize it, he needed an expert testimony. Turning to the res ipsa loquitur argument, the court first lays out the three elements, which are the first, the occurrence producing the injury must be of a kind which is ordinarily does not occur in the absence of negligence. Two, the injury is caused by an agency or instrumentality within the exclusive control of the defendant. And three, the injury causing occurrence must not be due to any contribution on the part of the plaintiff. An injury caused by an assault from another patient in a mental health facility is not the kind of injury that ordinarily would not occur absent negligence. And while Mr. Price, as an inpatient, was subject to the hospital's authority and control, that's not the same as saying that his actions were within the hospital's exclusive control. It was Mr. Price's independent, not hospital-controlled actions that caused Mr. Abdul-Wahid's injuries. And ultimately, the court held that the lower court did not abuse its discretion in denying a third continuance, and the decision to grant the motion for summary judgment was upheld. And I'll turn it back to Levi for our final case.
Thank you, Scott. So the first three cases that we have reviewed today have been two Division II Court of Appeal cases. The Abdul Wahid was out of Division III. The final case we're going to review this afternoon is Hermanson versus Multicare. And this was a Washington Supreme Court case that considered the boundaries of the corporate attorney-client privilege and how it operated when in conflict with a plaintiff's physician or healthcare provider patient privilege. And the case relates back to a car accident that occurred in Pierce County on September 11th, and I'm going to state September 11th, 2015. The patient in that case, Mr. Hermanson, sideswiped an unoccupied vehicle and crashed into a utility pole. He was transported to Tacoma General, owned by Multicare, and there he was treated by several Multicare employees, including 2 nurses and a crisis intervention social worker. However, the physician who treated the patient was Dr. Patterson, who was an independent contractor of Multicare. He was with an organization there called Trauma Trust. So Trauma Trust was Dr. Patterson's employer. He was an independent contractor of Multicare. As he was receiving treatment, they did a blood test. That blood test showed that his blood alcohol content was well over the legal limit, and it was reported to law enforcement, and who Mr. Hermanson was later charged with first-degree negligent driving, hit and run of an unattended vehicle. So based on the disclosure of his blood alcohol results, he sued Multicare, multiple unidentified parties, for negligence, defamation, false light, false imprisonment, violation of his physician-patient privilege, and unauthorized disclosure of his healthcare information. This case was assigned to our friend Dan Mullen to represent Multicare. And the defense attorney in that case asserted that they were going to not only represent Multicare, but also Dr. Patterson. And the plaintiff objected to that. And so the defense attorney moved for a motion for a protective order, seeking relief from the court that he could communicate to Dr. Patterson, the independent contractor of the named defendant Multicare. And just to be safe, also asked in the protective order that they could, the defense attorney could speak with the 2 employed nurses and the employed social worker. So that is kind of the lay of the land. The defense attorney wanted relief from the court to discuss the case under an attorney-client privilege with the independent contractor, 2 employed nurses, and an employed social worker. The trial court found that that the defense attorney could not have ex parte contact with Dr. Patterson, so it denied that protective order. It granted the defense attorney the ability to discuss the case with the 2 employed nurses, but it denied the defense attorney the ability to have privileged conversations with the social worker. So the case went up to Division II Court of Appeals, and Division II Court of Appeals affirmed that the defense attorney could not have ex parte contact or privileged communication with the independent contractor physician. So Division II affirmed that the defense attorney could not have ex parte contact with the independent contractor physician. It affirmed that the defense attorney could have privileged communication with the 2 employed nurses, and it reversed and said that the Division II said that the defense attorney could also have ex parte contact with the employed social worker. So that was the procedural history leading up to the appeal to the Washington State Supreme Court. Of note, there was a dissent from Division II that dissented on the grounds that the defense attorney should have the ability have privileged conversations with the functional equivalent of an employee. And so the dissent previewed this term, functional equivalent. So the case went up to the Washington State Supreme Court. The Supreme Court justice who authored the opinion is Justice Susan Owens, who is actually from my hometown of Forks, Washington. I played Little League Baseball with Justice Owens' son. Justice Owens wrote this opinion, and it is a great opinion for the defense bar. And our hats off to Dan Mullen and the appellate team for this good Supreme Court result for the defense bar. What the Supreme Court held was that as to the independent contractor physicians, that they carried on the analysis from Young's versus Peace Health, which stated in that case that the patient-provider privilege did not trump the attorney-client privilege so long as the provider that the defense attorney or the defense attorney was trying to speak with had firsthand knowledge of the alleged negligent event, and that those communications were limited to that alleged incident. And so in this case, the Supreme Court adopted and carried on the analysis that was first previewed in the Division II dissent and held that the defense attorney could have ex parte contact with a non-employed independent contractor who was a functional equivalent of an employee. Now, there was some dicta in the Supreme Court decision that revisited the Newman case, and the Newman case held that defense attorneys of organizations could not have attorney-client privilege with former employees. So I think the practice pointer here for the defense bar is a best practice is to determine is a functional equivalent an active functional equivalent or are they a former functional equivalent. If they're no longer with, if they're no longer serving the hospital system or the healthcare system, a best practice is to reach out to the plaintiff's attorney, let them know because of the allegations that this provider or former provider has knowledge of the alleged, firsthand knowledge of the alleged incident, that you're going to assert an attorney-client privilege and then see if they object. We've seen, I know I've canvassed some of our other defense attorneys. We've seen a mixed result here. We know that the Luvera firm is aggressively objecting to defense attorneys asserting attorney-client privilege with former attorneys. Know that some other plaintiffs' attorneys actually appreciate when we reach out, and they think it's actually more efficient and more convenient to just let the assigned defense attorney assert the privilege. They don't want to wait, have the healthcare system or the insurer go out and retain a separate defense counsel and add yet another defense attorney that they're going to have to deal with. So I guess the practice pointer would be for the defense bar to be proactive in identifying whether someone that the plaintiff identifies as having firsthand knowledge of the alleged negligent event, whether they are a active or former functional equivalent, and then just previewing whether or not you're going to assert attorney-client privilege with the plaintiff's attorney. And let's hope that you're not going against the Luvera firm and that you can talk them into it. It's really going to be more efficient if you just let me represent this former agent. The Supreme Court did not address whether if you assert somebody as a functional equivalent, I misspoke there and said agent. They specifically reserved and said, we're not going to say that if under this analysis that a functional equivalent equals an agent for the ostensible agency analysis. It most likely will, and that is a factor that I think the defense bar should be anticipating. If you say I'm going to assert attorney-client privilege over a functional equivalent, does that diminish your ability later on to say, well, I have the right to assert attorney-client privilege to a functional equivalent, but no, that's not our agent. I think that that's going to be a more difficult argument to make. And so it's something that the Supreme Court did not address explicitly in this decision, but something the defense bar should be anticipating. I'll move on to the nurses and social worker, and just a reminder, in the Youngs versus Peace Health case, that decision was limited to allowing physician, attorney-client privilege communication with physicians who had firsthand knowledge of the alleged negligent event. I think most of the defense bar just read into that, well, if they're going to apply it to physicians, then that also applies to other hospital employees, such as nurses, CNAs, other types of healthcare providers. And Hermanson just, I think, extended that to affirm that, yes, if you have another type of healthcare provider other than a physician, such as a nurse or a social worker or another type of healthcare provider, that yes, you can assert this attorney-client privilege for those hospital employees that have firsthand knowledge of the alleged negligent event. That was our case law update for the year. I want to finish showing, this is our what we call our LA law photo of the team here. I did want to highlight one other thing. I don't have a slide for it, but just an after action, a learning point that I had recently. A couple of years ago, the Washington State Legislature updated the mandatory arbitration jurisdictional limit, raised it to 100,000. And so I know that has been something discussed in our WHCRMS presentations, our quarterly presentations, now and again over the last couple of years. I wanted to highlight something that came to my attention recently as part of this new legislative update. They included that if you lose in a mandatory arbitration and you request the jury de novo, that it actually has to be the client that signs the request for the jury de novo and not the attorney. So that was just an additional practice pointer I wanted to share with the larger community that may have been mentioned, but was something I wanted to highlight that came to my attention recently. All right, everyone, thank you for your time. I know we maybe finished
it's great information to know for us and also all of our organizational members. It's always nice to get that case law update every year. So obviously some pretty important stuff that came out over the course of the last year, and especially I think that Hermanson opinion is something that we deal with frequently. So Levi, thank you very much. I really appreciate that. Scott, thank you. I think that now that's the end of the presentations, but I know that we do have, I think we have some gifts here to give away, the door prize recipients. And I know that Roxanne, I think, was going to go ahead and present that. So if Roxanne is there.
Hi, Michael.
Great, thank you.
So we have a couple of people here that I want to announce, and you must be present still to win. So when I call your name, if you wouldn't mind just jumping on either the camera or audio piece, so I know you're there, it would be greatly appreciated. So the first person for the virtual door prize would be Crystal Collins from CHI Franciscan. Is Crystal still with us?
I am.
Woohoo! Wonderful.
Yay.
Well, I will reach out to you after the conference to get the appropriate mailing address, and we'll send you a little goodie. So thank you so much for being a part of our virtual conference. We really appreciate it.
Yeah, thank you.
Okay, next person I have on here is going to be Matthew McCauley. Is Matthew here on the call?
I am.
All right, Matthew, you're winner number 2. So thank you so much for being a part of the WHCRMS conference. We appreciate it.
Thank you. Thank you.
Okay, that's all I have to say. I'll pass it back off to Michael.
All right, thank you, Roxanne. I appreciate it. So as we conclude, I wanted just to introduce the new WHCRMS board for the following year. I will be president for the next year. The president-elect is Roxana Jessen. The past president will be Michelle O'Neill. The treasurer is Ann Clark. The secretary is Danielle Donovan. Western Washington trustee Shelley Nick. Western Washington trustee Tim Hall. Western Washington trustee Sarah McComb. And Eastern Washington trustee Nathan Orlando. And I want to welcome all of those individuals to the board for next year, or for the next year. It's going to be a great year. Hopefully a little bit of a return to normalcy as we get through into the summer and into the next fall. I'd like to thank the former board members of WHCRMS, Sarah Silverman, Erica Roberts, and Leslie Robinson, who are no longer actively on the board. And I also want to thank former President Michelle O'Neill. Michelle provided excellent leadership over the past year, which for everybody was a struggle, and she maintained it and held everything together for WHCRMS, and we would not have had such a successful year without her. So thank you very much to her, as well as the other board members. Obviously, again, you know, the challenges that everybody's faced, and we were able to still have a very successful year, have great education sessions that were really well attended by everybody. I want to thank all of our members of the organization. Without everybody's participation and feedback and input, we would not have been able to have such a successful year last year, and hopefully provides a nice little bounce into the next year for WHCRMS, and that we can continue the momentum that we have right now. And hopefully, however, we'll be able to have some of these in person. In fact, Michelle talked about it earlier today. We're looking to try to put together social function pending CDC guidelines and kind of how everything is. So it's a little bit up in the air, but we really do want to try to have something in person so we can get back to meeting everybody face to face and seeing people and having some social interaction between our members. And details on that will be forthcoming here probably in the next couple of months. Also, over the course of the next year, we're going to have several education sessions. We usually try to have about 3 or so per year. If anybody has any topics or ideas, we encourage you to include those on the survey that you're going to be getting here in your email in the next shortly about the conference today. The information that we receive, the input that we get, it really does help formulate talking points and ideas for future education sessions, as well as for future conferences and speakers and topics. So please, or you can obviously reach out by email through the WHCRMS website or to myself. My email address is michael@jgkmw.com. And we can go ahead and try to incorporate ideas that people have into presentation topics. Also, please complete the survey for this conference that you're going to be getting by email soon. This is necessary for you to obtain your CE and CLE credits. This conference is approved for 4 credits from ASHRM, 4 CE credits, and 3.5 credits are pending right now from the Washington State Bar Association for the attorney friends who are on this conference. Lastly, I want to thank everybody for attending. You know, this has been a really good conference this year. It's been an interesting but still fun and educational year for us at WHCRMS. I hope that everybody in our membership feels the same way. And we're looking forward to next year being able to do more things in person and hopefully get back to going to the WAC. And Levi, I will take you up on a free beverage after our conference at the end of next year. But hopefully we can get back together with everybody and do this in person. Obviously, the ability and everybody's comfort level with video conferencing now, it certainly does expand maybe our reach and some things that we can do as an organization. So we'll be looking to try to maintain some of that aspect as well. But at the same time, we do want to bring back these in-person gatherings so we can have our social networking events. So with that, unless anybody else has anything further, I would like to just thank everybody for their attendance today, and we look forward to seeing you all next year. Thank you.